Can you hear us? Okay. Is that yes, or do you want us to turn the volume up? Because we can't turn up the volume. You have to turn your volume up. Can you hear us, Ms. Lundgren? I can't hear her, but.
She seems to be something that she can hear us.
Oh, it sounds good, very good. Okay, on the record, in the matters of the people of the state of Michigan versus Kathleen Burden, Amy Fascinello, John Haggard, Marianne Henry, Michelle Lundgren, and Michonne Maddox. Council appearances.
Good morning, LaDonna Logan on behalf of the people.
Good morning, Kayla Crino on behalf of the people.
Good morning, Your Honor. Mary Chartier on behalf of John Haggard, who is seated to my right.
Good morning, Your Honor. Lizzie Saylor, paralegal to Ms. Chartier.
Good morning, Your Honor. Nicholas Somberg on behalf of Michonne Maddox.
Good morning, Your Honor. George Brown on behalf of Marianne Henry.
Good morning, Your Honor. Paul Staplin appearing on behalf of with Ms. Fascinello, who is seated.
Good morning, Your Honor. Garrett Coder on behalf of Kathy Burden.
Good morning, Your Honor. George Danini also on behalf of Kathy Burden.
Good morning, Your Honor. Dwayne Sullivan on behalf of Michelle London, who I see is appearing on screen from Zoom.
Thank you. Okay, today was the date and time set to proceed with the defense witnesses. I do need to address an issue. You can be seated. Address an issue regarding a concern that was presented to the court, forwarded to the administration. Although the court does have a policy whereby you can have your personal cell phones out during a proceeding, at no time should photos be taken of witnesses, nor should there be Facebook or other public posts made with commentary about that testimony, especially disparaging comments. That's a contemptible issue. It also can teeter or be found to be consistent with witness intimidation, which is an offense that could be charged criminally. And so the court's going to have to address the issue that was presented to the court, and those parties will get a hearing notice at a later time. But I'm advising everyone, especially those in the gallery, if I see your phones out and it doesn't appear, because if you're texting, your phone should be down. But if it appears that you're taking a photo, I'm going to have to take your phone and have it searched, because we're not going to have witnesses being intimidated when they're coming in here under a subpoena to give testimony. Nor will I have to be taking time away from my judicial duties to address commentary made on Facebook posts. It's juvenile and it's ridiculous. There are multiple defendants in this case being charged with felonies, and let's take it seriously and conduct ourselves as such. Unless there's any other preliminary matters that need to be addressed, we can call our first witness.
There are no preliminary matters from Mr. Haggard. I believe it's the cross-examination of Agent Shock at this time.
Is there any other preliminary matters from any other defense attorney?
None from Kathy Burden.
And from Michelle London, Your Honor.
No, Your Honor.
If you can take the stand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. Counselor, you can proceed.
Thank you. Agent Shock, I know it's unusual. You've got to look at me this way. Just a few basics. It's been a few weeks since we've been here. You had indicated you started the investigation into this matter on or about December 28, 2022.
Yes.
And was the Attorney General's office involved with investigating this matter before you got involved?
Yes.
Who was that? Who was involved in that?
Agent Cronin, Scott Cronin.
How long had Agent Cronin been investigating the matter before you got involved?
I would have to refer to my notes on that.
Do you think it was, can you give us a roundabout, a year and a half?
I can say that it was more than a month, but I can't be certain beyond that.
So because I'm wondering what was the delay between December 2020 and then December 28, 2022, or when Agent Cronin started, which would have been approximately a month prior, you indicated.
I understand what you're saying. I don't know what the delay was.
So to your knowledge, Agent Cronin began investigating roughly a month, could be two, before you got involved, correct?
Yes, but I will say that Agent Cronin was also, there was a new position that opened up that he submitted for, and he was transferred to a new position. I do know.
To your knowledge, there was no investigation in 2021 by the Attorney General's office.
To my knowledge, yes, you're right.
And then it was Agent Cronin who kicked off the investigation in sort of the latter part of 2022.
That's my understanding.
Did the Attorney General's office work with any other agencies, the FBI, Secret Service, anything like that, when it comes to the investigation portion?
Are you referring to my investigation?
Well,
or-
the Attorney General's investigation. So you're an agent of the Attorney General. I'm asking you about the investigation at your organization.
Okay, and I can only speak on my experience. So I did, during my investigation, I did reach out to other agencies for assistance.
What other agencies can you recall?
The FBI, the national, there's an investigative department with the National Archives, the state police. Those are some that I can remember off the top of my head.
So you weren't just a one-person investigator. You at least reached out to other organizations or individuals when you believed you needed the help.
Yes.
And then were there other agents other than Agent Cronin who worked with you at the Attorney General's office on this matter?
Yes.
Who are they?
Special Agent Eduardo Torres and Special Agent Robert Lavone also assisted.
Thank you. Now, the affidavit in support of the complaint that you prepared, did anyone assist you in preparing this document?
Are you referring, there was many affidavits.
Sure.
Are you talking about the warrant affidavit? The
This is-
complaint warrant subpoena?
Yes, and I can show it to you if need be, if that will help you refresh your memory.
Look through all the pages here. Yes, I prepared the affidavit up to number 37.
And then who prepared after number 37?
I don't want to assume, but it goes back, once I prepare it, it goes back for review to my supervisor and then to the AAGs. So
who is your, may I take that back?
Yes,
Unless
of
you
cour-
need it?
of
Okay,
course,
great. So who was your supervisor who reviewed it?
Sam Miller.
And then who were the AAGs who were working on the case who would have reviewed it?
At the time, Assistant Attorney General LaDonna Logan. I believe it was Kayla Crino. And I'm not sure if Aaron Van Langevelde would have had review over that as well, but it goes off. Those are the Assistant Attorney Generals that are reviewing the material that I prepare at that time. But as far as the transition, when Assistant Attorney General Crino came on, I don't remember the exact date.
Sure. And you mentioned Assistant Attorney General Van Langevelde, and maybe mispronouncing his name, but forget it. You know who I
Aaron.
mean,
Oh,
right?
Well,
Well, I don't know him well, so I'm not going to call him Aaron.
okay.
But so was he involved in the investigation portion, or essentially, do you work in a bubble and then pass the information along, or are assistant attorney generals giving you guidance as to, for example, things I'd like you to follow up on.
No, I work in a manner that, as far as the investigation goes, it's independent. I will submit things for review periodically, such as affidavits for search warrants and stuff like that. The process is, like I said, the documents are submitted to review first to my supervisor. And then once he approves, then it goes to all 2 or 3 of them at the time. As far as what they do on their end, they review it over. They may have some questions or concerns about certain things, maybe punctuation and grammar. It's always good to have a second set of eyes.
Now, when I'm looking at 1 through 37, you prepared. So when you're citing, for example, statutes as it relates to Michigan election law, and also there are some statutes here for federal law, that is all from your work. No one is giving you that guidance.
Yeah. Yes, that's accurate.
Okay. And then is this your first election law case, or you had experience doing that before?
This is my first election.
Okay. How did you just do that independent research yourself on what statutes you believed were applicable?
Yeah.
Were you familiar at all with the Ingham County Prosecutor's memorandum on the conduct of the Republican electors?
I'm aware of it. Yeah.
Had you reviewed? Well, let me just ask you this: have you ever reviewed it?
Yeah.
And did you review it before you drafted this affidavit?
Yes, I likely reviewed it sometime at the beginning of the investigation.
Did you reach? That was, and again, you can correct me if you don't remember. That was prepared by an assistant prosecuting attorney and submitted to the elected prosecutor and another assistant prosecuting attorney. Did you interview any of those individuals as to their thoughts about the memorandum that they prepared?
I did not interview them. I don't know the process of how they shared it. I just reviewed the document. It's simply put, I reviewed the document. I did not interview them.
You'd agree with me, though, it was prepared by an assistant prosecuting attorney.
Yes, it was written. I think that's who authored it. I don't remember the name of that attorney.
Sure. Andrew Stevens, just.
Okay.
Okay. Now, did you work full time on the investigation, or are you also involved in other matters that you're also investigating?
No, I'm involved in other matters. That
what portion of your time, percentage-wise, do you think was dedicated to this matter?
This took up the bulk of my time.
Both meaning 80%?
I would say probably 60 to 70% of that time.
How many people do you think you interviewed?
Gosh, I couldn't give you an accurate number off the top of my head without referring to my notes.
Over 100, do you think?
I know that there was well over 100 reports written. I don't know. I want to be as accurate as possible.
Would you agree with me that it's a large number of people who you interviewed?
Yes.
And did you watch any news reports or media reports about the election and what electors were doing around the country? And by electors, I mean Republican electors.
I looked at media reports specific to this case.
Are you aware that there was a lot of media coverage about the election?
Yes.
And are you aware that there was a lot of media coverage with people having concerns about the election not being above board and being potentially fraudulent?
Yes.
Did you also look, and I believe you did based on your testimony, at the social media that the electors were, at the elector social media?
Yes.
Now, when you were investigating this case, you interviewed Kenneth Chesbrough, correct?
Yes.
And he was interviewed pursuant to an immunity agreement?
I can't speak about the agreement, but I did interview.
Was it a proffer agreement?
A
proffer agreement? Okay.
Yes.
And Mr. Chesbro, to your recollection, talked about the involvement of himself in this process, correct?
Yeah.
In terms of drafting documents.
Yeah.
And Mr. Chesbro is a lawyer, right?
Yes.
And Mr. Chesbro expressed his confidence that this was a legitimate process.
Objection, Your Honor. Hearsay.
It goes to the effect on the listener and why we're actually here and what was done in the investigation.
It's not being offered for the truth of the matter asserted.
No, Your Honor.
Objections overruled.
Thank you.
Could you repeat the question?
Sure. I'm paraphrasing Mr. Chesbro's lengthy interview and the emails that he submitted. But is it fair to say that Mr. Chesbro, when he was interviewed, talked about he believed this was a legitimate, lawful process that the electors were involved in?
Yeah.
And he was involved to make sure that it was a legitimate, lawful process that the electors were involved in.
That I can't answer as far as he believed he was involved with that.
Okay.
I don't want to speak for him.
Sure. So Mr. Chesbro told you he's a lawyer, right?
Yes,
That he thought this was a legitimate, lawful process that the electors were involved in, correct?
yes,
And then you also learned that other lawyers were involved in this process, right?
Yeah.
What lawyers did you learn about?
there was Sean Flynn, Stu Sandler. Sean Flynn was the Trump campaign aide. He was an attorney. Stu Sandler, the Michigan GOP attorney. I would have to refer to my notes. I don't. There's some attorneys that were on the peripherals as well, so I'm not sure if you're talking about that, but as far as the process I listed two, I would have to refer to my notes about the other.
Ian Northland, right?
You know, he was, again, that's where I was going.
Sure.
He's on the peripheral.
Okay.
He's an attorney.
What do you
That's my
mean by,
understanding.
I'm sorry, what do you mean by attorneys on the peripheral?
So he was at the Capitol that day as an attorney. What he was, if he was associated with the Trump campaign, the Michigan GOP, he didn't agree to an interview. So I didn't get to speak to him about that.
But he was on the Capitol on the day that that document was signed. And by that document, I mean this signed by the electors, right?
Yes.
That seems to me to be more involved than just on the peripheral. So what other lawyers do you believe were involved on the peripheral?
So I can't answer that because
Okay.
just off the top of my head, your first question was getting to the lawyers that were involved in the process. So
Sure.
I know that Ken Chesbro had drafted some documents. He was sitting, had sat down for an interview. I spoke to him directly about that. I know through other eyewitness accounts that Sean Flynn was involved. He is an attorney. I researched to determine that. As far as the others go, you know, I'd have to refer to my notes or look at statements that where people suggested that specific attorneys were involved in agencies.
Going back to this affidavit in support of a complaint, are you the one who takes this to the court to have it signed off?
Yes,
Okay, so I just want to make sure I'm clear on the process. You draft it, it goes to your supervisor to review it,
yes,
then it goes to lawyers.
yes,
And then lawyers, meaning the assistant attorney generals, they make whatever changes they need to or add things to it, right?
they could, but go ahead, continue.
Oh, sure. Well, so, because you said you drafted through 37,
Right,
and this goes through paragraph 45. So someone added 38 to 45, correct?
yes,
And it wasn't you.
No.
It could have been your supervisor, or it could have been an assistant attorney general, correct?
it wouldn't have been my supervisor because he would have communicated that directly with me.
Okay, so some attorney general, assistant attorney general, excuse me, added paragraphs 38 to 45, right?
Yeah.
And then you took this to the court, swore to it, and got it signed.
Yes,
The social media that you reviewed, well, let me jump back before. You had testified on direct that and I know this was a couple of months ago, but you had no evidence of judicial action as it related to the 2020 election. Do you remember saying that or something like that?
Something like that.
What did you mean by that?
So specifically at that time period, so meaning December 14th, I didn't have any evidence of that as they're going in to vote during this time period.
But you were aware there were lawsuits pending, correct?
I was not aware of it. I mean, as we spoke about earlier, this is a national event. And so there were 6 or 7 states involved. So there may have been lawsuits out there. For me to look at every single court across the nation would be quite difficult. So I'm just speaking about the information that I was aware of at the time. And I didn't have that.
And even courts in Michigan, right? You didn't check every court in Michigan to see any pending lawsuit, correct?
Correct.
So as you sit here, you might not have been aware of it, but you don't know if any existed, correct?
Right. So that I'm speaking about what I was aware of.
Right. And then when it came to social media that you reviewed the social media of the Republican electors, and I don't want to put words in your mouth, so tell me if I'm wrong, to make sure essentially to see what people were thinking, what they were posting about their actions, to try and get at some idea of what people's intent was. Is that accurate?
Yeah.
And you presented a significant portion of that when we were here the last time in court. I think there were tens of thousands of pages of people's social media. Even if it's not all applicable, it was still presented, right?
Yes.
And then you even read some of it out in the court about what people were thinking, or at least saying about what happened, correct?
Yes.
And that's because you think that that may be valuable information for the court to know in order to make a determination on this case, right?
Yes.
Now, the Attorney General in this case is Dana Nessel, correct?
Yes.
Were you aware that she made comments on September 18th, 2022, that the electors in this case were brainwashed?
Objection, Your Honor. The court has previously made a ruling that that was inadmissible in this exam.
Not with me. I mean, no, I wasn't involved with that.
I didn't even hear what she said.
She's making a question about statements made by Dana Nessel. I recall there being a motion to dismiss based on that. I don't recall a motion in limine.
I believe the court in the ruling denying the dismissal said that those statements were not admissible
If
or
I
relevant to
They weren't
these
relevant.
proceedings.
So if your objection is relevant, that's different.
Relevance and hearsay.
may I, Your Honor? I believe the motion to dismiss was filed by Mr. Brown as it relates to Ms. Henry. We did not join in that. They're not offered for the truth of the matter asserted. I don't think that Attorney General Nessel can know if somebody's been brainwashed or not, but it does go to a timeline of this investigation, which I believe is relevant, and I can make an offer of proof if the court would like.
So if you can explain how this is relevant.
Yes, so Mr. Renner, who testified at our last time that we were in court, was interviewed on September 12th, 2023. And Mr. Renner made a number of comments, but including essentially that in his opinion, individuals, this is what he actually testified to, the electors were conscientious individuals attempting to do the right thing. And that they were told this was an appropriate process. And again, I'm paraphrasing his testimony and his interview. Then on September 18th, and I said 2022, I meant 2023. Mr. Renner is interviewed on September 12th, 2023. Dana Nessel makes her statement that the individuals, the Republican electors, genuinely believe Mr. Trump won the election. And they legitimately believe it, that they were brainwashed. They couldn't plead guilty because they really believed what they did was right. And she makes that on September 18th, 2023. And it's actually recorded. So it's not a private comment. And I am curious if Mr. Renner's statement was shared with Attorney General Nessel, and that may have been a prompt for the statements that she publicly made about the mindset of the Republican electors. And I believe that is relevant because for an Attorney General to make a statement as it goes to intent, which is contrary to what her office charged, what prompted that statement, I think, is significant. And I do think it's significant to ask Agent Schock because he was involved in the Renner interview on September 12th, 2023.
Your Honor, that calls for speculation to say that the Attorney General's comments were predicated upon hearing this information, and that's why she made the comments. This witness cannot testify to that.
Well, I don't know if that was her question. I think she's just trying to establish a timeline first. The other issue is this is a statement made by the Attorney General. And she's questioning an employee of Attorney General about him drafting an affidavit to charge these individuals.
And the affidavit was drafted in July of 2023.
I think she's trying to, but I think her goal is to try to establish a timeline. For that purposes, I'm going to overrule the objection. I'll allow you to ask.
Thank you. So Agent Shock, we'll walk back.
Yes.
We'll walk back. I know there was a lot in the group. You were involved in the interview of James Renner on September 12th, 2023, correct?
Yeah.
And in that interview, Mr. Renner shared his belief that the individuals involved, and again, I'm paraphrasing, were conscientious individuals attempting to do the right thing.
I would have to refer to the report to specifically recall what Mr. Renner said.
Well, did Mr. Renner indicate that he believed this was a legitimate process that the electors were involved in?
Again, I would have to refer to the notes. If you
I have the report
Yeah.
right here.
That would be helpful. Thank you. Is there a specific paragraph or?
He talks.
And then you can.
Okay.
So, based on a review of my report, it was his belief that he believed that Donald Trump may have the ability to win.
Okay. And did Mr. Renner say anything in that interview, and granted it is reported, to indicate that he genuinely believed that this was an appropriate process that he was involved in?
I would have to review that.
Well, let me ask you this. After Mr. Renner gave his interview to the Attorney General's office, he was given an immunity from prosecution, correct?
Well, I found that out later, of course, but yes.
And that was in October of 2023, roughly. That sound about right?
It's probably, yeah. I don't have the specifics. Again, as I mentioned earlier, there was hundreds of reports written. That's why I'm asking to reference this report as far as the specifics.
And you also heard Mr. Renner's testimony in court, correct?
Yes.
And you were here listening to that?
Yes, but it was several months ago.
It was several months ago, but let me ask you this. Did he say anything in court that you think that's totally contrary to what he said when he was interviewed?
I don't believe.
Right. And so he essentially, and I'm summarizing here, believed that this was a legitimate process, correct?
Well, that's your words. I don't, again, I would refer to the report specifically about Mr. Renner's opinion of the matter.
Well, did the Attorney General give immunity to someone who believed they were committing a crime?
Could you repeat that?
Sure. The whole point of the immunity given to Mr. Renner was that he believed this was a legitimate process, right?
I don't know what the point of, I don't know what I was involved in the immunity. Okay, I'll just say that. So I'm not involved at that level. Okay, so that's why I'm having a difficult time answering your question. As far as what Mr. Renner felt at the time, or what he testified in court, seemed to match the report that I created.
Okay.
I have not had the ability to see the transcripts and see what he said in court. So I'm just putting the two together. Okay. As far about, you're trying to summarize what his intent was. I'm going to refer to my specific notes of what he said specifically rather than, accepting your summarization.
Sure. But I think you said it, and I want to make sure that I'm clear. To your recollection, Mr. Renner's testimony matched what Mr. Renner said in his interview.
Yes,
After Mr. Renner's interview, do you know if Attorney General Nessel was briefed on Mr. Renner's interview and what he said?
so I know that I don't know. No,
Who does brief her?
I brief on my updates for my investigation, but beyond that, I can't tell you.
So what does that mean, you brief on your updates to the investigation?
So periodically, I will say I've completed this interview, I've completed that interview. This is what I've done. This is what I have to do.
Is it done in writing that she would have access to, or do you go in and physically meet with her
It's through a Teams meeting.
through a Teams meeting? Do you recall if there was a briefing between September 12th, 2023, and when Attorney General Nessel made her statements on September 18th, 2023?
I don't. And I'm not involved, I work for the criminal investigation division. And then we have the assistant attorney general division. So there is a separation there, and we have a chain of command. And so it would be improper for me to, reach out to the attorney general directly and say, hey, this is what's going on. I always have to go through my supervisor, my immediate supervisor. But if I'm called into a meeting, of course, I can provide an update. Again, it's what I've accomplished and what I need to do. In terms of strategizing, that's the attorneys that would handle something like that. I strategize more on the investigation side, and they would strategize on this side. I don't have a jurisdiction.
So you write this report from September 12th, 2023, and then it gets approved by a supervisor. That's SAM.
Yes, that's Sam Miller, who I mentioned earlier.
Okay, Sam Miller. And then you don't know, though, because you have been in briefings with the Attorney General, correct?
Yeah.
Right. You don't know if between September 12th, 2023, when the Renner interview was conducted, and when Dana Nessel or Attorney General Nessel makes her statement that the electors genuinely believed in what they were doing. They legitimately believed it on September 18th. You don't know if there was a briefing between September 12th and September 18th.
Again, I would have likely taken place in a briefing, but it would have been only to the extent that I completed the interview.
But the interview would be accessible to Attorney General Nessel, correct?
When I was done with the report, yes.
But what about the audio of the interview?
Yes, that would be it.
That would be accessible, correct? Do you know the basis for Attorney General? I'm just trying to figure out if it's coming from you or someone else. Do you know the basis for Attorney General Nessel's statement that the electors genuinely believed that what they were doing was appropriate? Do you know where that came from?
No.
After the statements were made on September 18th, 2023, knowing that this was an ongoing prosecution of electors, and the Attorney General said they genuinely believed it, did you ever speak to a supervisor or anyone about the disconnect between those comments and this prosecution?
No.
Did you ever try to speak to anyone about it?
My supervisor is aware of what I was doing, continuing to pursue the investigation, continuing to gather evidence, continuing to do interviews. And until I'm given an order to redirect or to do something differently, then I keep traveling on that path.
Do you ever raise red flags if you think that a lawyer is doing or saying something that is contrary to, for example, an investigation or prosecution? Sure, because you said you just sort of keep going with the investigation. You have a supervisor.
Right.
And I'm wondering if, regardless of any conflict, you just believe that that's outside of your job duties, or do you think that is a job duty and you've done it before?
So to speak to conflict, I present the facts in the information, okay? If there's a conflict that exists, it would that determination would be made above my level. If if I felt that somebody was lying, as I was interviewing Mr. Renner, and I felt that, I've received information that was contrary to what he was saying, then of course I would bring that up to my supervisor. But again, I gather the facts and the information and present them, and then there's a determination about what may be a conflict above my life.
Okay, and would that be Mr. Miller or would that be another lawyer?
No, that would be above potentially Mr. Miller. I don't know who that person would be or group of people. But it would likely be, above his level. Again, he's my supervisor, so I'm not intimately familiar with all the duties and responsibilities that he has.
To your knowledge, has anyone discussed in a Teams meeting or anything else, the conflict between Attorney General Nessel saying that the electors genuinely believed in the process, in what they were doing, and a prosecution based on intent to defraud? And again, I'm paraphrasing because obviously the complaint is significantly longer, but has that, you understand the conflict I'm raising? Has anyone addressed that to your knowledge?
Not to my knowledge, no. It hasn't been with me in a specific meeting.
And not in any email communication, anything that you're aware of? No additional questions, thank you.
You're welcome.
We need to take a brief recess because IT needs to remote into her computer to clear some data. So I don't know how long it's gonna take. I don't know how long it's gonna take, so it's about 9:48. Come back at 10 o'clock. Hi. I'm confused.
I don't know, but I see Anithia.
Anithia, were you guys looking to zoom into our courtroom? Oh, okay.
Yes, Judge, we are going to try to make this an overflow because we have people out in the hallway. So Judge Ward is done and she said that, you know, let's pull it up here and then we can make it an overflow. Is that okay? Oh, there she is.
All we need to do is just kind of mute this and stop hard.
Thumbs up if you can see us in courtroom 1.
Okay. Yeah, so like we were listening in the hallway, so.
Gotcha. Okay, sounds good. Thank you.
Thank you.
Did you share? And did you make this?
That's how I took it, like not being part of chambers and all that, that's.
Are they done for today? In here. Let's give me the overflow. Wait a minute now. Let me go investigate this further. If they are done for the day, it's cooler and larger in there. Why is that the overflow? This should be overflow.
I think they are done for the day. But I don't like shows.
Let me see. I'll leave this one. So I'll just have to switch and then log in and go into that Zoom room. Is that what I'm gonna do? Let me see.
I intentionally tried to bring less.
Oh, I'm good, thank you.
Gotta make sure it's long break today.
Oh,
Oh, I'm going along into my
Oh,
Zoom, yeah. I don't even know if it's necessary for me to bring all of these files. Probably not. Yeah, Judge Wood usually wipes her stuff down, but I can't say anything about the rest, I'm sorry. My lord, it's hot in here. Get all my purple pens. Ooh. I need help.
We're moving them to, Judge Ward is done.
Why are you laughing? It's toast, isn't it cozy in here?
It's a little toasty.
That's because we're gonna have a medical emergency in here. We're gonna have a medical emergency. Sean, come, he can't take his coffee. He can get his coffee off there.
You want to bring this?
Yeah.
What else can I help you with?
I'm going to carry this.
Oh, it's heavy.
Guys,
thank you. That's how you.
Ooh, well, you're doing just fine. I think James got it all set up, so I think I'm not the best at how to count. Okay.
Just make sure that the mic, you're watching from the game, so people talk.
I'll come down there time to see if we're still in years, but.
Oh, thanks, John, for gathering our goods.
I know,
Yeah.
and,
And I can grab the rest.
not
Head on
guilty,
down.
I know. Oh, I got it, John, thanks.
My bad.
Yeah, that's what we were doing.
Right. Juries.
This one's mine, this one's yours.
Okay, so that one's mine.
Where do you want me to
Okay.
grab for you?
Can you grab that other black bag?
Yep. Your base
Okay,
bag?
cool, yes, please.
Yep.
Lizzie's got it.
Yeah, I grabbed the thing, John.
Okay,
Plugging
cool.
everything.
We got everything, all right. Let me just confirm, I want to make sure we don't need
I
it.
asked the judge too that she had permission to move.
Oh, thank you.
Well, there's a cup there.
Yeah, don't stop, go.
Why?
We gotta get going, Jimmy. I gotta get set up in here. Good, how are you?
Good.
You got an upgrade.
Hello there. Yeah, play our musical chairs for a while, but that worked out. It won't be so sticky.
Oh.
Okay, clear it out. Yeah.
Testing. Ms. Lundgren, can you hear us? Okay, you can't, I don't know what's going on with the possibility. I asked for Ms. Lundgren if she could hear us, and someone came to the. Okay, you can hear me now, okay, thank you. Okay, Ms. Lundgren is here and everyone can hear us. We can proceed, thank you.
I'm not sure if you had the answer. Who can provide you with the necessary guidance on election law and procedure?
So I've reviewed the information that was already introduced and presented to me. Looked at any statutes that may be applicable. And then, as within the investigation, you're looking to determine if the facts or the elements of the statute at the time.
Yes. How did you know what statutes to look at?
Well, I had a document with some signatures on it. The document was not the document that was originally on file with the Secretary of State. So I started looking in the direction of what election laws are out there that may be applicable. Forgery statute, again, looking at that information.
You consult any experts or do you consult any experts to determine if
Be more specific about who an expert will be.
an expert or authority, somebody more experienced in election law? What specific legal criteria did you use to conclude that a crime had been committed?
I don't authorize the charges. Okay, I gathered the facts, the information, I put that together, supporting whatever time. The prosecutors determined that, and the judge again signed off on the affidavit authorizing that.
You agree this is a case that has to do with political expression? Case by election.
It's a case that involves election law, forgery, and publishing. It involved the 2020 presidential election.
So how did you determine what was just political expression? How did you distinguish between political expression and actual criminal offense?
Based on the information that I gave. Some of it are statements that are not specific to the document, and other statements that were made or other information that was gathered was specific to the document and then the mailing.
In your experience as an investigator, have you ever encountered a situation where individuals acting on legal advice, openly following what they believe were lawful instructions were prosecuted?
I don't recall this situation.
Did you uncover any evidence that directly indicated my client, Mishaps Maddox, that she understood her actions to be illegal at the time she performed?
I would have to review the material to look at specific statements. Well, you're talking about whether or not she knew that it was
At the time that
illegal.
she sort of alleged act.
And I don't recall. I would have to review the material.
isn't it true that my client as well as the other defendants cited specific statutes and legal precedents to justify their actions?
You need to repeat that?
Yes.
Repeat it.
Can you speak up just a little bit?
Absolutely. You reviewed a lot of social media on this case, correct?
Yes.
You watched a lot of video content, correct?
Yes.
And those are things, video contents, including broadcast by the media.
Yes.
And it shows online and traditional TV.
Yes.
And in your investigation, isn't it true that my client and other defendants cited specific statutes and legal precedents to justify their actions?
I believe that they made citations of specific statutes. I would have to review the material.
Sorry, were you gonna say something?
Hawaii, I remember a Hawaii reference.
And at any point during your investigation, did you come across any instances in which similar actions taken by members of other political parties were ignored or not prosecuted? At any point during your investigation, did you come across any instances where similar actions taken by members of other political parties were ignored or not prosecuted?
Can you be more specific?
Sure.
I don't understand.
In your investigation, did you find a Democrats or Green Party or Libertarian taking similar actions, but in your investigation, no charges were issued against them?
So I'm aware that the Democratic electors, they signed to submit their electoral votes. I'm not aware of whom.
Did you find any evidence suggesting that my client received any personal gain? Any money out of this?
I did not find any of it.
And that's what I mean by personal gain. Is there any sort of, there's no promotion of any sort, correct?
Well, the event was promoted. I don't know what, are you promoting, are you talking about a promotion at work or what?
I'm giving you examples. So typically in a fraud case, somebody's trying to gain something, benefit, but maybe a bad check for money. Okay. In your investigation, you agree that Michon did not receive any personal gain.
Well, the outcome was that the votes were not counted by vice president. So that's a personal gain that you're referring to.
Did anybody offer her money?
Again, I said that I didn't have any evidence that anybody offered.
Mr. Shag, when I asked about it, as part of your investigation, you obtained a search warrant for Give Send Go LLC.
Yes.
And that was focusing specifically on fundraising efforts for legal defense as detailed in the search, correct?
No, the focus was the statements that were made on this.
Did you write the search warrant?
Yes.
Agree. In the search warrant, you pursued detailed information about legal defense fundraising efforts, including their subscriber information, financial transactions, and communications related to fundraising plans.
I would have to refer to the affidavit itself. The focus was statements that were made.
But you did request the financial information in the search warrant.
I'm doing that to determine if who the account is owned by, and to determine if the person that has the picture on that page It's actually the owner is the person that may be responsible for inputting that information.
How did that come, you didn't request a warrant for that until this year?
So it was last-
Or was it the end of last year? That's okay. Why did you decide to do that?
Again, like I said, it was about statements that were made saying that, you know, if one of the defendants had posted on their Gibson website or the other site, that they were an elector and that they committed this act. Again, that's my.
In your experience as an investigator, how often are fundraising platforms subpoenaed for information outside of cases involving direct financial fraud or investment?
I can only speak to what I.
Is it the first time you subpoenaed somebody's fundraising efforts for legal defense?
Yes. First time that, again, I was looking for statements that support the action on that.
Do you agree that the search warrant specifies the need for all financial transactions, donations, contributions, givers, transfers, bank accounts, and routing numbers?
If that's what the affidavit says, again, I would have to refer to that. If you'd like to provide that to me, I can review it.
And this information is more than just their statements on the page itself.
I'm trying to show ownership here. So that's when I'm crafting an affidavit, I'm trying to identify the owners, show ownership. And again, focusing on the state.
You're trying to show who I'm sorry, you're trying to show who owns what.
Who owns the account? Who owns the account? The Gibson Go account? Who made the statements? That's what I'm trying to determine. So the more information that I can gather to support that, that's.
You specifically looked at Michelle Maddox's Twitter account, correct?
Yes.
And you looked at her Facebook account.
Yes.
And you screenshot and included all things you found relevant in your investigations, your reports, correct?
Yes.
Before going into Twitter, just back to the Gibson Go, just briefly, who came up with the idea to subpoena Gibson Go?
Either them or search.
Either way.
I don't recall that. Again, when I work with my boss and we kind of collaborate and we talk about that information. So I don't recall specifically.
And so was it something that you were investigating and you came upon this page and decided to issue a search warrant, or was it something presented to you?
So again, after the defendants were charged, I continue to monitor social media, and almost daily I'm reviewing that information. And so how I came about it, I don't recall unless it's documented in a report.
So you don't recall somebody gave this information to you?
I don't. There's such a large amount of information about this event, this case out there. So I don't recall how it came across.
I want to go back to, I want to ask you about what your investigation produced of Deshawn's Twitter account. And you agree that she tweeted on December 14th, 2020, the date in which this document was sent.
And I'd have to look at the tweets to all that. Again, there's there's search warrants done to Facebook, Twitter, Instagram with thousands and thousands of pages of information.
If I showed you a copy of your incident report, would it refresh your recollection?
Yes, sir.
Your Honor, may I approach?
Yes.
I can't read the second photo here, but I can read the first paragraph and looks like a Twitter post.
You're able to read in the black section, the
Yes.
actual post.
Yes,
Has your memory been sufficiently refreshed?
yes.
Thank you. You agree that Michonne herself stated that they did not replace any Democratic electors.
That's what she said.
And you agree this is just an intent to operate within the law.
Don't follow that portion, the intent operating.
No, and I'm sorry, she didn't state that. But do you agree that the fact that she, on the day of that this happened, stated that they did not replace any Democratic electors?
She did say that.
Yes, and my follow-up question is, do you agree that this suggests an intent to operate within the law?
I can't speak to what was going on in her mind with that specific statement.
Do you agree that in this tweet, Michonne explicitly clarified that their actions were intended to send their pledges to Washington?
The word pledges is in there. You know, I don't, again, give me a second, look at it. I don't remember pledges in there, but I remember saying votes, sending our votes.
And this, a crime like this has not been, you agree this is basically a crime of first impression. Charges like this have never been issued for this type of behavior. Ever. Okay. Well, I mean, do you agree with that?
I'm aware of the fact that we charged 16 people here in the state of Michigan for this purpose. I'm not aware of the cases that may be active in Wisconsin or Nevada or Arizona, Pennsylvania, Georgia. I'm aware, obviously, Georgia, that there was a case brought against those individuals, but as far as specifics.
In that case in Georgia was well after December 14, 2020. Right?
Yes.
You've investigated fraud crimes before.
Yes.
And forgery crimes before, right?
Yes.
And these cases are typically financial in nature.
Yes. Whether it's identity theft or check fraud, and title fraud.
So my point is that in your investigation, Michonne's not a lawyer, right?
To my knowledge,
Your
no, I
investigation.
found no evidence of her being an attorney.
So would you agree that her posting publicly, candidly, what they did at the time, the day that this happened, indicates a complete lack of criminal intent?
Objection, Your Honor, speculation. The question was which,
I'll ask it better.
are you good?
I'll strike a question, strike the whole question, sorry. In your investigation, I'm sure you come across people who commit a crime and then they're trying to cover their tracks. Yes. Ms. Shawn's tweet that day was, do you agree, was in an effort to be, was indicating her belief in the legitimacy of what they did.
Yeah, objection, Your Honor, calls for speculation.
How is he supposed to answer that?
So it's a specific intent crime. So it's what I'm. You can ask. You can say that whether or not what she posted on Twitter at the time.
We cause him to believe that she had specific intent.
Yes, or the elector.
I'll answer. Objection to the.
So there was many posts that she had on that day, Twitter, Facebook. Would I agree with you that specific word would not support intent? Yes, but other statements did support intent that I found. Statements about phony. I mean, there's a whole host of social media posts, videos, and stuff like that about votes, casting their votes and sending them to the DC.
Made by this defendant?
Yes.
None of her votes, none of her statements in your investigation ever acknowledged that she believed she was doing something illegal.
No.
She never said she was trying to cheat anyone.
Again, I would have to refer to the Instagram, the Facebook and Twitter posts. I don't recall hearing the word cheat.
Do you recall watching an interview on the show Crossroads?
Yes.
And what did you learn from that interview? What did you learn in that interview about? How did it further your investigation?
So, provide just a quick summary based on my recollection without pointing to the notes on my report. I believe it was with Ms. Maddox and Mrs. Sheridan and with a television host, and they said that they cast their votes, they met, they cast their votes, and they were sending them to yes.
And is it true that Mrs. Maddox articulated her belief that they were following both U.S. constitutional law and Michigan statutes by attempting to submit the ballots?
Yes.
And in that same interview, Mrs. Maddox called for investigations into the election irregularities and expressed concern overall for the integrity of elections in Michigan.
That part I don't.
No further questions. Thank you. Thank you.
Morning, Chuck. I'm gonna just ask you a quick few questions about Give Fund Go, because I wasn't gonna do that, but since Mr. Sundberg did. So you said during his questions that your focus was on statements that were made on that platform, right?
Yes.
And that you were trying to determine ownership of the pages or something like that?
Yes.
You're aware it's expensive to defend yourself in a criminal case?
Yes.
You're aware lawyers charge fees?
Yes.
And those fees can mount up?
Yes.
And we're at a preliminary exam stage of this, and it's already been countless hours spent defending this case.
Yes.
Are you aware perhaps that was not your intent, are you aware that your search warrant caused the defendant's ability to raise funds to significantly diminish? You aware of that? That wasn't your intent.
No, sir.
Okay, let's talk first about Mr. Jim Renner's testimony here. You were here that day, correct?
Yes.
All right, and so he told, by the way, did you review his transcript prior to coming today?
No, I have not.
Okay, but you were here.
Yes, sir.
You heard him and saw him on the witness.
Yes.
Do you recall him telling us that he has been involved with the Clinton County Republican Party for about 10 years?
Yeah. Check. It's not proper to ask the witness to come in and testimony.
Your Honor, this is the lead investigator of this case. He has interviewed Mr. Renner. He has heard him testify in open court. I'm going to explore the testimony, his interview of him, how it impacted his decisions. He has testified here today that he on almost a daily basis is monitoring the wires. He continues his investigation. And so anything that's going on in this case is ongoing investigation that this man is continuing to do, and it's proper for this court to hear and make a final decision.
He's been questioned by another attorney about Mr. Renner's testimony.
Yeah, I'm objecting to that too.
I think as it relates to their question, it's appropriate. I mean, obviously he can't just give opinions about another witness's testimony, but if he's trying to elicit a question about how that relates to his investigation, that would be relevant. Let's overrule.
Thank you, Your Honor. So he's been involved in Republican politics for about 10 years.
Yes.
And that, do you remember him telling us how he got to be there on December 14, 2020?
Yeah.
And that's because Janelle Leonard called him?
Yeah.
And he got a very short notice about showing up, correct?
Yes.
Maybe a day or two prior?
Yes.
And he's one of these, we call the two replacement electors, right?
Yes.
He was not one of the original 16 who were elected to be Republican electors at the Republican State Convention back in August of 2020, right?
Yes.
But the other people, including Kathy Burton, was elected, correct?
Elected on which day? The August convention?
That's right.
Yes.
This is, I can show it to you if you want. This is Defense Exhibit A, which has already been admitted, certificate of the Republican presidential electors elected at the Michigan Republican State Convention, August 29 to 30th, 2020.
Yes.
You're aware Kathy Burton was elected on that day as a Republican elector.
Yes.
And do you know who Janelle Leonard is?
The wife of Tom Leonard?
And do you know who Tom Leonard is?
Who's the name?
Former Speaker of the Michigan House.
Yes.
So if Miss Leonard called and asked Mr. Renner to be there, you're aware from your investigation that Kathy Burton has no involvement in Mr. Renner being there December 14, 2020. Is that right?
I have not found any evidence.
Are you aware, both in his testimony and when you interviewed him, that Mr. Renner said he had no reservations about agreeing to attend the meeting on December 14th, 2020?
And we have to look at my report.
Okay, that's fine. And he had no knowledge, real knowledge about the presidential electoral process and how it worked before showing up on that day, right? Do you have any evidence to suggest that Kathy Burton knew anything about the presidential electoral process before December 14, 2020?
I do know that she was involved in politics leading up to that. Specifically, what her knowledge or intimate knowledge is.
Okay,
I didn't get a chance to interview her, so I don't know. But we didn't.
sure. But in your entire investigation dating back to December of 2022, I understand she was involved in Republican politics. My question is more specific.
Okay.
Did your investigation uncover any evidence that she knew anything about the presidential electoral process prior to showing up on December 14, 2020? No. Other than being asked by Stu Foster to show up a couple of days prior, to show up on December 14, 2020, do you have any knowledge that she knew anything about what she was walking into when she arrived at the MRP headquarters on December 14, 2020, just before you? Do you recall?
Can I back up?
Yeah, I tell you what, you may have, if Ms. Logan or Ms. Crino has some follow-up, they can do that.
Okay.
Do you recall a text message between Troy Hudson and Stu Foster where, remember, Troy Hudson and Stu Foster are both with MRP, right?
Yes.
Okay. They work under Laura Cox?
Yes.
Okay. And you're aware that they were the ones that were involved in getting these individuals to the MRP headquarters on December 14, 2020, right?
Yes.
And Stu Foster was the one that called Ms. Burden, right?
Yes, but Mrs. Burden had received, well, there was an email that was sent out by Mr. Chesborough leading up to this.
Yeah, we'll get to that, but since you brought it up, let's talk about it right now. Mr. Chesborough sent her an email prior to December 14, 2020.
Yes.
And when I say her, that's Ms. Burden.
Yes.
She never responded to that email.
I found no evidence of that.
Well, somebody else responded, right? But Ms. Burden never did.
Mrs. Sheridan.
But Ms. Burden did not.
That's correct.
Okay, so, and you know from your investigation that not only did Ms. Burden not respond to that email, but Ms. Burden had no contact whatsoever, phone, text, voicemail, anything with Mr. Chesborough. He told you that, right?
Yes.
So back to this text message. So again, these are the people that are involved. And when Troy Hudson is telling his subordinate Stu Foster to get these people there on December 14, 2020, do you remember that Mr. Hudson told Mr. Foster, quote, "Don't say sign a document, just say meet ahead of time," close quote. Do you recall that text?
Yes, I do.
Okay, because I have it here, but
I
do you
do
remember?
remember.
So, so you don't have any evidence to suggest then that Ms. Burden was informed she'd be signing any documents at this meeting prior to her arrival, right?
I don't have, focus on the text for a second. I recall the text. I don't remember who that exchange was between.
Sure, I can show it to you, but it's between Troy Hudson and Stu Foster.
Oh, I knew it was Stu Foster. I didn't know who the other was.
Would you like to see it? Okay. But you remember it, you've testified.
Yes.
And so, not only don't you have any evidence, but we know specifically that there was a direction not to tell Ms. Burden that she'd be signing. Fair?
There was a text message that said, don't tell anybody about signing it or not.
Fair enough. Okay. Mr. Renner testified that the purpose of the December 14, 2020 meeting was to develop an alternate slate of Republican candidates / electors. Do you remember that?
I don't. I have to refer to.
All right. Do you remember him telling us that his understanding was that there were two purposes for the document that he signed on? Do you remember that? All right, let's see if I can tell you what he said and see if you recall. Okay. His first purpose was to present the Republican votes alongside the Democratic votes in Michigan Senate at 2 p.m. on that same day. Remember that being essentially his purpose number one?
Yes.
And the second purpose was to be a placeholder in the event former President Trump won a recount or some other challenge that resulted in Trump winning in Michigan. Right?
Yes.
And he said, in that event, the electors wouldn't have to come back and meet again if that were to happen. Remember that?
I don't remember that.
Okay, but essentially you remember those two purposes I articulated. Okay. Do you remember Mr. Renner explaining as to his first purpose number one, that essentially just went away and disappeared when the people that walked over to the state capitol at 2 p.m. were denied entry by Lieutenant.
Yes,
Okay, so his purpose number one gone when they weren't allowed into the capitol. Okay,
that's what it said.
okay. And just as an aside, you're aware that Kathy was not at the capitol at 2 p.m. on December 14th, right? She went home with her sick and dying husband directly from the Michigan Republican Party headquarters. You're aware from your investigation, correct?
I have received statements that suggested that may have happened, but I didn't have anybody in a car with her, traveling with her, so I did not interview anybody. So that's maybe what some people say, but I don't have any evidence to, you know, where an eyewitness said I rode in a car with her, we went directly.
Well, her husband's since passed, so it's kind of hard to ask him.
And then people started.
You watched the video that was introduced by the prosecution team in this case outside the Capitol building, correct?
Yes.
Did you see Ms. Burton in that video?
No, I said that just a moment ago. I didn't have any evidence of her being in the video.
Yeah, but I'm asking you a specific question. You watched the video and you did not see Ms. Burton in that video.
That's correct.
That video captured who was present outside of the Capitol building at 2 p.m. or slightly before 2 p.m. on December 14, 2020.
Well, it captured the people that were within the camera's view. So there may have been people standing outside of the view that it did not.
Okay, maybe she's hiding in the bushes.
I'm not saying that, Mr. Janine.
On the second purpose, do you agree that Mr. Renner's testimony makes it clear that that is a contingency event?
Yes, Mr. Renner did say that.
Basically, something had to happen after December 14, 2020, but before January 6, 2021, correct?
I don't remember that specifically saying.
I'm asking you specifically, isn't it fair that something would have had to happen? Trump would have had to have, and we'll get into some of the testimony, but Trump would have had to have flipped the state of Michigan between December 14, 2020 and January 6, 2021 in order for this certificate of this alternate Republican certificate of votes to have any legal consequence or significance.
I can't answer that.
All right, so we'll get to it. All right, and Mr. Renner said he got there just a little before noon, is that right? Do you remember that?
Sounds right.
And when I say there, December 14, 2020 at the MRP headquarters.
Yes.
And you're aware that's around the same time Kathy Burton arrived?
No.
Okay. Do you have anything in your investigation to suggest she got there any earlier?
There may have been. I just don't recall.
And he too wasn't told anything about signing documents prior to the meeting? He too, Mr. Renner.
Mr. Renner. I would have to look at the report to know what he was told by Mr. Jim or by Mr. Blunt.
And do you recall him testifying he had no knowledge of how Ms. Burton became the chairperson, or whether that was something that was selected at random? Do you remember that?
I do not. I do remember that one of the witnesses indicated it was a voice vote.
So basically, at the meeting on December 14, 2020, sometime afternoon is when she was named or voice voted as the chairperson.
Yeah.
Does your investigation suggest she had any advanced knowledge that she would be named by voice vote as the chairperson?
It does a little bit based on the information that I received from Mr. Chesbrough. And Mr. Chesbrough had a Excel spreadsheet with the elector's names and contact information. And I believe Mrs. Burden had something labeled next to her name that might indicate that, but I would have to refer to those.
Okay, we'll take a look at that too later, but basically, I know what you're talking about. Mr. Chesbro didn't know Ms. Burden from the man in the moon, right, before this?
Yes, that's true.
He was provided a list of the 16 electors in the state of Michigan,
Yes,
just like he was provided the names of the electors in the other 6 states.
yes, and that came from the Michigan GOP.
Yeah.
So they would have had that information. They provided it through the channels. But that information signifying for designation would have been on there going up through those two.
Right, and all that did was identify what her role was within the Republican Party prior to this date. Is that fair?
Yes.
It had nothing to do with chairperson.
Again, like I mentioned, I would have to look at that specific document to determine what he said.
Okay, and just, I don't have it here, but for the record, because I know what you're talking about, Mr. Chesbro got an email with the names of the Republican electors from Michigan in a spreadsheet, correct?
Yes.
That spreadsheet had 16 names, right?
Yes.
And it had, if they had a title essentially associated with them, they had their title.
Yes.
And she was the Republican National Committee woman, right?
Again.
We'll look at it. Okay, fair enough.
If you want to put that on the record, you know, I would have to look at it in order to give you an honest answer.
That's fine, but, sir, this is your investigation, right?
Yes.
You've been at this since December of 2022?
Yes.
You've been doing this 70% of your time, I believe it was 60 to 70% of your time since then?
Yes.
And I remember the document.
There's thousands of pages, but you have to keep in mind, you're focused on one client. I have 16 defendants in all the documents that are associated with this. So the amount of information you're focusing on is specific and relevant to your client. Mine is much broader.
Yeah, but I got all the stuff you gave us.
I believe.
All right. All right. So I just want to be clear, as you sit here today, you have no memory that that document that you're talking about, that Mr. Chesbro had, that identified her as one of the 16 electors, to identify her as a chairperson. Well, you're saying you just got to look at it.
I just said that I have to look at it. There was a designation there. I just don't know. I took an oath when I got up here, so I
You
want
doing
to
it?
make sure that I'm honest and I'm accurate.
All right. That's good. Okay. Okay. Back to Mr. Renner briefly. He also testified here in court that these alternate certificate of vote were to be used only if, quote, Trump was determined to have legally won the election, close quote. Do you remember that?
Yes.
And if former President Trump had somehow legally won the election between December 14, 2020 and January 6, 2021, in your opinion, would the alternate Republican certificate of votes have been a properly signed document on December 14, 2020?
I'm not able to make that determination.
Well, sir, I'm gonna ask that you do. I'm asking you that there is plenty of evidence in your investigation that this was a contingent document. My question was, if the contingency came through, okay, I understand it didn't, but had the contingency come through, something happened between December 14, 2020 and January 6, 2021, would this document have been a properly signed document in your opinion?
So there's a number of different lawyers' opinions on this matter that I've come across in my investigation. Some say yes, some say no. In fact, Miss Land, when I had interviewed Miss Land about whether or not, why didn't she appear there, was because she didn't feel that it, would carry any weight. There was no purpose of doing. Several people that I met or interviewed made that determination that there, even if there was something that occurred in the courts, that it necessarily wouldn't change things. There was a number of different scenarios that that could possibly play out. So that's why I can't answer your question, because again, we have attorneys that had a difficult time coming up with a decision on that and arguing amongst each other, those even on the Trump team.
And that's all fair. So just to restate that a little bit, so people were debating this very question I asked you, right?
Yes,
Legal scholars came out on either side of that question, fair?
yes,
Some said yes, it mattered, and some said no, it wouldn't have mattered, fair?
yes.
And you investigated those differing opinions.
And that's just what they were, opinion.
Right.
There wasn't any event that took place to change all that. So what we're proposing is, well, should haves, would haves, could haves. I can't speak on it. I was called upon to investigate the information that I had in front of me and followed that along, but you know, a number of different outcomes. You're asking me specifically to make a determination on that. And I don't have the ability to determine that. I don't have the, what I do know is that the document was created, the document was signed, the document was mailed. There was no recount. On December 14th, I was not aware of any court action. I was aware of, you know, the Speaker of the House, Lee Chatfield, Mike Shirkey, had said that there was nothing that was going to change the outcome of the election, and I'm paraphrasing here. So that's what I was for.
Okay, so sir, you know, you tried to, and I don't say this disparagingly, but you tried to minimize your role here. You're just the guy that's developing the facts, right?
I'm not minimizing.
Okay, you develop.
I take my role very seriously.
You develop the facts, right?
I don't develop them. I gather them.
Fair. You gather the facts and you presented a lot of that information, or I say some of that information in affidavit, right?
Yes.
And that affidavit, you swore to under oath, fair?
Yes.
And you said, and we'll get into it a little bit, you said that somebody on the AG team drafted at least a portion of that document, right?
And we're talking about the affidavit.
In support of charges.
Charges, okay, yes.
I mean, specifically, you said you drafted paragraphs 1 to 37, right?
Yes.
And somebody on the team over here drafted paragraphs 38 to 45.
Yes.
And I guess while I'm doing it, did anybody provide you with edits to paragraphs 1 to 37? Did your boss on the criminal investigation division side do it?
I don't.
Did any of the prosecutors do that?
I don't recall.
If they did, would you have incorporated their edits if you agreed with them?
Yes. I'm the one that's swearing to it.
Sure. So you got it. I mean, so even paragraphs 38 to 45, you had to agree with, right?
Right. That's swearing to it.
Right. And all the legal research you did, because there's a lot of legal research that went into paragraphs 1 to 37. You're citing statutes, you're doing some other things. That's all you. That's your testimony?
Yes.
Okay, sir. We went off on a little bit of a tangent, but I'm going to come back to my question. You told us about other people's opinions. You talked to us about different opinions on the question that I posed. But I want you to answer my question. Do you need me to restate it?
Yes.
Had Trump, former President Trump, legally won the election between December 14, 2020 and January 6, 2021, okay? Whether that's a recount, whether that's some court case, whether that's the state legislature doing anything, whether Congress did something, if that happened, would the document that was signed, People's Exhibit 14, be a proper document?
Objection, Your Honor. Asked and answered.
Not answered, Your Honor.
It was answered. If you didn't like the answer, but it was asked and answered. It causes for speculation and it causes for legal confusion.
I agree that there's possible conclusion. I also believe he answered the question because he said he wasn't in a position to answer that question. And that's an answer. So that's the objection is sustained.
Now, when you swore out your affidavit, you write in there that the alternate electors, quote, knew prior to their meeting on December 14, 2020, there was no legal reason to create an alternate slate of electors, close quote. Do you recall writing that in your affidavit?
Yeah.
You just testified that certain legal scholars and lawyers believe there was a legal reason to do that. Is that correct?
Yes.
Now, when Ms. Chartier asked you to rattle off any other lawyers that you would call as being part of this case, the very first person you talked about was Sean Flynn. Remember that?
Yes.
Do you remember that Mr. Renner testified that Sean Flynn was present on December 14, 2020, and appeared to be the one that was kind of running the show?
Yes.
Have you charged Sean Flynn?
No.
Have you interviewed Sean Flynn?
No.
Now, we talked about this a little bit, just got a couple of questions about it, that Mr. Renner testified that some of the people were going to present the documents at 2 o'clock at the Capitol, right?
Yes.
And you're aware that there's a state law requirement about when the vote is supposed to happen of electors?
Yes.
And that's, again, a state law requirement, not a federal requirement, correct? You're aware in 1960 Hawaii, both the Democrats and the Republicans met together to cast their respective votes?
Yes.
But in 2020 in Michigan, the Republican alternate electors were denied entry. We talked about that, Lieutenant Green, correct?
Yes, the 1960 event was different than the 2020 Michigan event.
Okay, we're going to talk about 1960 Hawaii since you just brought that up. Now, clearly the 16 Democrat electors who were in the Senate chamber at 2 p.m., they knew that they had just voted, right?
Yes.
What evidence do you have that Kathy Burton intended to lead anyone to believe that the document at issue somehow negated the Democrats' certificate of votes?
None.
Mr. Renner testified that there was no plot to defraud anyone, right?
I have to again refer to his report.
And
that specific statement.
in this courtroom, when he testified, it was crystal clear that if there was any such plot, he would have never participated. Fair?
You remember that, yes.
And he was equally clear that he made no agreement with anyone, no agreement with anyone to commit a crime. Remember that?
Yes.
Mr. Renner's perception of the events on December 14, 2020, based on his observations of everyone there, was that it was entirely legitimate. Do you remember him saying that?
I do not.
Let's take a look at that.
Yeah.
I'm gonna go ahead and I'm just gonna read it. See if you like that. And if you don't, then I'll hand it up to you. This is Mr. Renner testimony on page 52, lines 6 through 12. My background is enforcing the law, not breaking them. I brought my family up that way, and we respect the law. So to the extent that I knowingly had been told, first of all, that this was a questionable process, I would have raised my hand and said, let's discuss that a little bit more. But the actual opposite occurred. Do you like to see this?
No, I remember that. Yes.
And Mr. Renner considered the election fraud allegations, and he specifically referenced the allegations at the TCF Center to be, quote, very serious issues that had not been addressed, close quote, as of December 14, 2020. Do you remember that?
Yeah, I'm gonna remove my objection, basically going over the entirety of Renner's testimony before this court, which I believe the court remembers what he testified to. There's no reason to go through it again with this witness.
I'm
It's not
thinking
part
he's
of the
going somewhere
investigation.
with it. I think it's gonna be a scenic route, but I think we're going somewhere. Am I wrong, Mr. Janini?
You're not wrong with Olson.
Because there's no other reason why he would rehash when we were all present for that.
That's what's been happening, Your Honor. That's why I'm removing my objection.
I think he's trying to align, I guess, the testimony from Mr. Renner to what your witness yielded from his investigations, what I'm assuming is happening here. So the objection is still.
All right, so let's just summarize it. His two main takeaways from the December 14, 2020 meeting were that the process was legitimate and this was not a questionable process. Do you recall that?
Yes, that was it.
And Mr. Renner testified that while Ms. Burden and Ms. Rodriguez appeared to be running the meeting because of their titles, that people behind them seem to be telling them what to do and say, and that's Sean Flynn specifically, right?
Yes.
And Mr. Flynn is the Trump lawyer, part of the Trump campaign, who ran this, I'll call it second unsanctioned by the MRP meeting. You know, is that fair? Or you tell me what Mr. Flynn was doing. Yeah, okay, and so let's try to do it. Laura Cox, head of MRP, right?
Yeah.
You heard her testify.
Yes.
She wanted to have a meeting, which she described as a ceremonial.
Yes.
And to sign the document that Ms. Burden signed and had notarized. We're gonna get to it a little bit later, but you know what I'm talking
To
about?
sign it, yeah.
And have it notarized.
There is a notary or a space for a notary on.
Okay. And then that meeting kind of starts and finishes, and then there's at least a continuation or a second meeting that Mr. Flynn kind of takes over. That, at least that's how I view the events that day.
Looking at the information, if it was a matter of Mrs. Burden signing just that document, then why are 15 other people coming? So
I can tell you one thing, Ms. Burden had no idea.
We'll just strike that comment, Your Honor.
Second. It was a motion to strike. his
oh,
comment.
okay.
Sorry.
That's anyway.
My fault. Go ahead, if you can remember, otherwise I'll.
I go ahead.
Well, on that day, okay, December 14, 2020, starting at noon and ending whatever it was, I think we had multiple people testify. Maybe it's 45 minutes, maybe it's an hour, maybe it's an hour and 15. Is that about the range?
Yes.
Okay. Do you agree that there was a meeting that the MRP had envisioned for that day? Through Laura Cox.
Yes.
And that's, at least part of that was the signing of Defense Exhibit B, which is the, and I'll give it to you, the one that Kathy Burden signed and notarized.
Yes.
Okay. And then there's almost a shift, and the Trump campaign takes over through Sean Flynn, and then People's Exhibit 14, at least the signature page gets signed.
There was one person that I interviewed that stated.
Who was that? Sorry. Who was that? I'm sorry. Yeah, you were going there and I don't know.
believe it was Troy Hudson said that. All the other people that I had interviewed did not say that.
How about Tony Zan?
Tony Zammit, no. Tony Zammit was aware that there was a document, but he did not get into the specifics that Troy Hudson did. You're talking about the fact that Sean Flynn took over. Troy Hudson was the only person that I interviewed that stated.
Because he was there, right?
He was one of a few people that were there. He was the only one to suggest it.
And his testimony that he suggested was that he up and left because the MRP meeting was over.
Yeah.
And that's when Sean Flynn took it.
Yes.
To your knowledge, that's true. And we know from your investigation, your emails and whatever else that Sean Flynn took possession of the plaintiff's exhibit or People's Exhibit 14, and he was the one that mailed it out the next day, correct?
When you say People's Exhibit 14, refresh my memory.
Sorry, the offensive document in this case, the
Yeah,
public
yes,
and alternate certificate of votes.
the interviews that I did, Tony Zammit had indicated that he saw Sean Flynn with those documents. That was the last person that he saw with those documents.
We'll get to it a little later, but let's do it now. On December 15, 2020, you have evidence that Sean Flynn was the individual who mailed those documents from the East Lansing Post Office. Isn't that correct?
I have evidence. I don't have evidence to say that for certain. Okay, I have evidence to suggest, and what I mean by that is he corresponds or in some manner to Mrs. Burden, asking her for permission to use her address mail at the time. And there's an email exchange between him and there's a few people on the email exchange basically indicating that he had a conversation with her. He has permission to use her address on the document. We talked about postal inspector was up here, what information that we had available to us during that as well. So do I have a witness or physical evidence that says that Sean Flynn was in a specific post office at a specific time, paying in a specific manner? I do not.
All right, we'll get to it. I think you do. And you got your testimony is almost right. Let me clarify real quick. Sean Flynn connected through Stu Foster to get to Miss Burton. Is that fair?
I don't.
We'll look. Okay. All right. Your Honor, just making you aware, I'm moving to a new subject. I don't know whether you want a break. I'm happy to keep going. I just wanted to let you know I'm in the transition. Okay, I want to focus a little bit on some of the litigation that's ongoing. Okay. Okay. And I remember you saying on cross-examination in response to Chartier that you said, she asked you about cases that were going on at the time. I wrote down that you said, quote, for me to look at every single court case across the nation would be quite difficult. Do you remember saying that?
Yeah.
So you testified that this is 60 to 70% of your daily job, right?
Yeah.
If it's difficult for you, do you think it's difficult for a former farmer, retiree, who doesn't have a law degree to know what's going on with court cases across the country in the state of Michigan? Couldn't answer that.
I don't know, what resources that she has available to her, being connected with the, Michigan GOP as a candidate for elector, and what sort of relationships she has with them, because now you're talking about a number of different resources that I don't have. So I can't, and that's why I can't answer that. So it's not, I'm not being disrespectful to your point.
You know that even though she has a title, she's a volunteer. You're aware of that?
I understand.
She's not paid for being on a part of the Republican Party. You're aware of that, right?
Yes,
She shows up for some meetings sometimes, and that's about it.
I don't know, I can't answer that, what she does,
You didn't investigate it?
not specifically like what her daily activities were, no.
They seem to be focused on the fact that she's the chairperson, she's the national committee person. Don't you look into those things?
I look into matters that are directly going to support evidence that would support the elements in front.
I suggest to you that you should also look at things that don't support. Oh, great. Anyway, so you were generally aware of litigation surrounding the 2020 presidential election, correct? Yeah, you were aware that there was.
On your last sarcastic remarks.
Yeah, and it was, and you should.
Strike, Your Honor.
What was the question?
Never mind, it's withdrawn. You're aware of litigation involving the 2020 presidential election, right?
Yes.
Were you keeping tabs on it?
So you have to remember, I investigated this after this litigation took place. So I looked into litigation that was taking place at the time and looking through court records and things like that. So does that answer your question?
It does. So basically what you're saying is you weren't focused on it in December of 2020, but you certainly were after December of 2022.
Yes.
And what kind of allegations do you remember seeing in your investigation of those cases? Do you remember any of them?
I remember there was some allegations of voter fraud and irregularity.
Now, there were a number of cases that were filed in the state of Michigan. I just want to know if you recall looking at any of these that I'm about to go through. Constantino versus the city of Detroit. So you mentioned at least some of the things. Let me tell you and see if they resonate, the things you heard about. In that case, there were allegations of forged ballots. Did you ever hear any allegations like that? Illegal voter coaching. Did you ever hear that? Changing dates on ballots so that they'd be counted when they shouldn't have been counted. Illegal double voting by certain individuals. Out-of-state vehicles dropping ballots off in the middle of the night. Did you hear any allegations like that?
I do remember that, yes.
The lack of transparency in the ballot counting process. Do you remember that? Remember there were some allegations they kind of put a big board over the windows and people couldn't look in?
Oh, that's what, yeah, I remember that.
People not having access to something called the qualified voter file.
Yes, I remember that.
Do you know what the qualified voter file is?
I'd have to refer to my.
I mean, it's basically, if this refreshes, do you recall the qualified voter file being a list of essentially people's information and signature, and then that's something that the actual folks could be married up against.
That sounds.
And signature issues on the absentee ballots. Do you recall that? And chain of custody issues. I think there were some allegations about that. Do you recall that?
Chain of custody issues with the votes.
With the votes, yeah. Let's take a look together at, are you aware that in the Constantino case and other cases too, that there were affidavits that were submitted to the court in conjunction with those complaints and allegations?
Some of the court cases I did look at, I don't remember specifically this Constantino's case, but I do remember affidavits. And there was a lot of other supporting documentation when they filed with the board.
Okay, so your memory is that in connection with the court cases filed in the state of Michigan, there were affidavits and other supporting documentation in conjunction with the allegations.
I would, yes, but I wouldn't say specifically with the state of Michigan. I would say yes in general. I don't recall about the specific cases in the state of Michigan.
There was a, and I'm going to ask you, just I'm going to read some of these, just only doing a little bit, but I want to see if this, you're aware of allegations like these. This is an example. So in the Constantino case, there was a gentleman by the name of Jesse Jacob that filed an affidavit. And he states, in this,
I'm going to object. This sounds like hearsay.
well, it's going to, again, I don't go to the well too often, but it's the effect on him. That's right.
Can we establish that we exactly read this before we talk about the effect? Because if he hasn't read it, there is no effect.
I'll rule the objection, but if you did it, you should have
Oh, Your Honor. Oh, you said you reviewed a number of cases, right, in your investigation?
Yes, sir.
A number of them in the state of Michigan.
Yes.
Constantino versus the city of Detroit was one of those cases.
I don't recall. That's what I said. I have to refer.
Sure. And I don't have your notes here, but there were a number of cases filed in the state of Michigan, and this was the one. This was one of the significant ones that went up to the Michigan Supreme Court. You looked at a number of them. You just don't have a recollection of this one specifically.
Yeah.
Okay. And you said you did look at affidavits and other supporting documentation, right?
Well, a number of different cases.
Okay. Do you recall reading the affidavit of Jesse Jacob?
I do not.
Okay. Could you have?
What?
Could that have been one of the affidavits and other supporting documentation in connection with these various cases that you could have reviewed?
I could have. I just don't recall.
Let's see if you remember what Mr. Jacob said.
And I'm gonna renew my objection that there's not enough foundation laid that this would have had an effect on this witness.
Your Honor, if I may,
Okay.
just respond. In fairness to the witness, he's reviewed a lot of stuff and he has expressed over and over again his lack of recollection of specificity with respect to those things, because he's got a lot on his plate.
You're trying to refresh his recollection here. Is that what you're gonna do?
Yeah,
Can it be shown to the witness instead of read into the record?
Yes, you can show it.
well, I want the court to be aware of what's in here too.
Well, we have to decide if it's gonna come in first. Here's an objection.
May I approach the witness, Your Honor?
Yes.
All right. I'm handing the witness the Jesse Jacob affidavit that was filed in connection with the Constantino versus City of Detroit case in the Wayne County Circuit Court, dated November 7, 2020. And I'd ask the witness to review this 19-paragraph affidavit, and you can pay attention to that
Yes, I vaguely, remember what you did.
You speak a little louder, this is a larger courtroom, so everyone. just
I
keep your voice
vaguely,
up.
remember reviewing that, in the investigation.
The objections are.
Let the record reflect, I'm handing a copy of that affidavit to the Assistant Attorney General. While they're doing that, would you agree with me that affidavits are evidence?
Yes.
And they're effectively, it's like a preview of what somebody might say if called to the stand like you're testifying today. There.
Yes.
Now, if you don't remember, that's okay. Are you aware that the Wayne County Circuit Judge in that case denied what's called injunctive relief in this case on November 23rd, 2020?
Yes, yes, that sounds familiar.
And that was the same day that the State Board of Canvassers met to certify the election. Do you remember that being a significant day too?
Yeah.
And Mr. Van Langeveld was on that State Board of Canvassers and cast a vote in that direction. You remember that?
Yes.
Now, that case, while that decision happened on that day, are you aware that this case wasn't ultimately dismissed until January 8th, 2021?
I don't recall.
Now, you said that your memory was refreshed, and you believe you did look at this Jesse Jacob affidavit, is that correct?
Yeah.
As the lead investigator looking into these issues, and you know that there were these at least allegations of voter fraud, right?
Yeah.
Does it matter to you as the investigator if somebody who was working for the city of Detroit and assigned to the elections department for the 2020 election was instructed by his
Your Honor, going to object again, and I know that the court thinks we will affect on the listener. However, the testimony has developed that this case was dismissed in January 2021, and Investigator Shock's investigation did not begin until December 2022. There has been no foundation for effect on the listener for a dismissed voter challenge.
Where are we going with this line of questioning?
Well, Your Honor, this witness is again the investigator who says that there was nothing going on essentially that could have changed things after December 14, 2020. And this is evidence of voter fraud, and I want to know if it mattered.
So your line of question is whether or not this case still pending had any effect on the decision that he made to offer the affidavit probable cause for the question. It's relevant.
It's the content of the affidavit. Your Honor. You can ask the question without reading the context of the record.
Okay, I don't have to read it, but I have to paraphrase it.
No, you don't. He's
Yes,
read
I
it.
He read it to make sure he had prior knowledge of what you were gonna ask him about. You don't need to put the contents of that into the record.
But Your Honor, I think that one of the fundamental things here is we know today that there were no issues of fraud, voter fraud, that could have overturned the election. Fair?
Okay.
But there are at least some people that didn't believe that to be the case as of December 14, 2020. And so if there are these things out there in the public domain, which this was, it's a publicly filed document, that had allegations from real people, this one being a city of Detroit employee who worked for the elections division, who was instructed to do improper things. Those things, if believed to be true, and could have impacted the election between December 14, 2020 and January 6, 2021, are very much relevant to these proceedings.
You may.
You may.
In December 2022, when this investigation is taken over by Investigator Shock, we know what happened with this legislation. And to ask Investigator Shock, well, this was pending until 2021. Could this have affected somebody who may have heard about it? That's speculation all on his face. We know what happened with that legislation, and ultimately nothing happened with it. It was dismissed, it was unfounded, and to go back a year and 11 months and say, well, somebody might have thought this was legitimate. We can't do that. That's not how that works.
Well, I think his question is whether or not the fact that there were these allegations that in fact, again, his decision, he's the one who authored the affidavit of probable cause under penalty of perjury that these people committed these crimes.
Oh, I'm
So
okay with
he-
that question.
I think what he's asking is not for him to determine whether or not, back then, if people possibly have hurt or aware of it. I think we've already established that by prior testimony, but whether or not that would have had an effect on the decision, ultimate decision he made, I guess, to have this charging document issued is what I believe is where we're going. Am I-
And Your Honor, with all due respect, we're exactly looking backwards. That's what we do in court cases. So Mr. Shock, while not assigned until December 22, is providing facts to a judge to authorize charges based on these people's intent as of December 14, 2020. So what they knew or didn't know on that date is 100% relevant to these
I agree
proceedings.
to that.
But my point, Your Honor, is whether or not that this case, Constantino versus the city of Detroit, was pending in December of 2020. This witness cannot say that any of the defendants was aware of it. I'm not objecting to the witness talking about the effect on this witness. I am objecting to the bootstrapping of saying that because this was pending, the defendants had a legitimate question about the election. This witness cannot testify.
We previously asked this witness if there was anything that could have, I guess, I'm paraphrasing now, legitimized this document that was filed. And so I think that's what the People's Exhibit 14.
Oh, and he said he didn't know.
Right, so I think that's what he's trying to establish, that maybe he did know. So it's also goes to credibility.
So, as the investigator, looking back on the facts as they existed back on December 14, 2020, to attempt to establish specific intent, you agree that this is, that at least some of these offenses are specific intent crimes, right?
Yes.
That these people had to know they were doing something wrong. Right? Did it matter to you that there was a city of Detroit employee assigned to the elections department for the 2020 election, Mr. Jacob, that said he was instructed by his supervisor to adjust the mailing date of these absentee ballot packages to be dated earlier than they were actually sent? Did that matter to you?
Yes.
Yeah, I thought we agreed that the witness could answer the question without being edited, right?
We did agree with that, but at this point, Mr. Ryder, it doesn't really have much effect on the decisions I need to make. It really helps him answer this question, I suppose.
How did it matter?
He did answer,
How
but
did
it did matter.
How did it?
It was, it's information that led me to an interview with Mike Shirky and asking him, you know, what was his responsibility? What did he see? What did he hear? Was there, he referenced the McBoom report, okay? So again, he told me that we didn't have it on December 14th. There wasn't anything, that was gonna assist us in the courts or somehow change the direction of the election. It wasn't gonna overturn. So that's what led to that interview. And so, does that answer your question?
Well, but it inspires a few more. So Senator Mike Shirky, you interviewed him, right?
Yes.
And he said that he came to the conclusion that there were not sufficient allegations of voter fraud to overturn the election, right?
Yes.
And he came to that conclusion shortly before December 14, 2020, right?
Yes.
I mean, that's just one man's opinion, fair?
No, it's based on a lot of interactions that he had with whether, people. So whether they were attorneys or whether they were people in the party, that's
fair. You think Senator Mike Shirky was more informed about the 2020 presidential election than Ms. Burke?
That causes me to speculate. I don't know. Again, I didn't get a chance. I interviewed Mike Shirky, right? And I didn't get a chance to interview your client. So I can't answer.
They say he talked to lawyers, and others, and he's very much following things, and his role as the Senate Majority Leader certainly caused him to be paying attention.
Yes.
Did you see in here where there were allegations of coaching voters to vote for Joe Biden?
Yes, I did see that.
Did that cause you to do anything in your investigation?
Just continuing to interview people and gather as much information as I could.
And did it concern you that he states that he saw election workers going into the voting booths with voters to watch them vote and coach them who to vote for?
Yes.
Did it concern you that he says that he was instructed not to look for any deficiency in the ballots that were cast?
Yeah.
Did it concern you that he stated that he was instructed not to compare the signature on the absentee ballot with the signature that's on file in that qualified voter file system?
Yes.
Did it concern you that he said that he was instructed to improperly predate absentee ballots, their receive dates, that were not in the QVF, as if they had been received before November 3rd, 2020? That concern.
Yeah.
And he says that the reason to put it in the QVF was to falsely show that the absentee ballots had been received in time to be valid. That concern.
Yeah.
Sir, is it fair that if those allegations, and those are only some of the allegations that were floating around at the time, if some of those allegations were true and corroborated, and a court said that that could have impacted the election after December 14, 2020, isn't it possible that the state of Michigan could have flipped in favor of former President Trump?
That causes for speculation. I mean, anything's possible. I don't know. And I suppose that answers your question. Anything's possible.
That's good. All right. I'm not going to do a lot on these, but do you recall the case of King versus Whitmer
Yes.
and other allegations of voter fraud? Fair?
Yes.
One of the allegations said that if there was a favorable resolution of the allegations of voter fraud, that the election could change from Biden to Trump. Do you remember that that was an allegation in the complaint?
I
Fair. How about this had allegations of computer systems being hacked? Do you remember anything about that?
do just vaguely. I don't remember specifics. Again, I would have to look at it through.
And this case, there was a cert petition filed to the Supreme Court of the United States on December 11, 2020, ultimately dismissed about a year later on December 21st, 2021. Were you aware of that?
I don't recall that. I would have to look at it.
Just to state the obvious, if I'm correct, and it was still pending as of December of 2021, then it was certainly pending on December 14th.
Yeah, that's.
How about Bailey versus Antrim County? Do you remember that?
Vaguely.
That was that whole software
In terms of the
glitch.
tabulator,
Yeah, remember that?
I do.
And basically the allegations were there were a bunch of votes that came in for Trump that were in Biden's column. Remember that allegation?
Yes.
And that the software that was used in Antrim County was used in about half of the counties in the state of Michigan.
That part I don't.
Okay. And for that case, that issue, we know today, that didn't turn out to be substantiated, but that was what was going on at the time there.
Yes.
That case wasn't dismissed until May 18, 2021. You aware of that? Fair. How about Stoddard versus City Election Commission? You aware of that case?
I don't recall.
Now, this one actually was over by December 14, 2020. Are you aware of that? Stop. Oh, you said you didn't remember.
I didn't.
Oh, fair enough. How about cases outside of Michigan? Did you look at any of those?
The Texas one comes to mind. All the others, I don't recall.
The Wisconsin one, Trump v. Biden.
Vaguely remember looking at that, yes.
Okay. This one actually gets dismissed by the Wisconsin Supreme Court on December 14, 2020. Were you aware of that? I think there were some text messages about that. Do you remember that at 11 a.m. or so?
Yes, there was, well, no, not the Wisconsin one. I don't remember. I know Mrs. Burton had posted something about the Texas one being dismissed.
Okay,
And I can't, and it was before December 14th, when she posted that, but I don't remember what you're on the Wisconsin.
so Wisconsin, one thing, Texas case, Texas versus Pennsylvania, right? The Texas case, which is called.
I think it was Texas.
And we'll get to it, but you said you knew that Ms. Burton posted about it, the decision, right?
The Texas case?
Yeah.
Yes,
Because you put that in your affidavit.
yes.
All right, we're gonna look at that later. Are you aware that Michigan was kind of involved in play, so to speak, in that Texas versus Pennsylvania case?
Yes. If we're talking about the same Texas case,
I think we are.
I mean, some of our defendants were listed on their plaintiff. Is that the case you're referring to?
Yeah. Not Ms. Burton.
No.
When I say not Ms. Burton, Ms. Burton was not a plaintiff in that case. Right.
Yes.
Okay. Let us take a look. Well, let me ask you, if you need to see it. You say you use that in your affidavit in support of the charges against Ms. Burton, right?
When you say you're using that, what are you referring to?
That is one of the facts that you included in your affidavit in support of the 8 felony charges when filed against Ms. Burton in this case.
When you say that, what are you referring to?
That is the fact that Ms. Burton was at least tangentially aware that the Supreme Court dismissed the Texas versus Pennsylvania case on December 11, 2020. And specifically in paragraph 34 of your affidavit, you state that Ms. Burton knew about the U.S. Supreme Court dismissal of that case on December 11, 2020, based on a post you made on social media, right?
Yes.
But you didn't stop there. You went on. Your affidavit goes on and made the leap of saying, prior to the meeting of the Republican candidates for elector, Mrs. Burton was aware the courts did not find evidence of voter fraud that supported overturning the presidential election. Do you recall writing that?
I do vaguely.
May I approach, Your Honor?
Yes.
Oh,
Is it after you?
Yeah.
It's in part.
it's in the file. So directing your attention to paragraph 34, that's what I read from. Please tell me if I read the sentence correct. Oh, I'm sorry. Oh, no, sorry.
Yeah.
I'm wrong. I gave the wrong. My apologies. Because the one that didn't get printed properly. So what I handed you before was just hard to get affidavit. My apologies. So go on to page 34. Or paragraph. Oh. So did I read correctly the quote?
Yes,
Now, we just went through a bunch of cases, and at least my representation to you that a number of them were still pending after December 14, 2020.
Yeah.
Okay. Don't you think it's a leap to say that one case is dismissed and that Ms. Burden is aware that the courts, that all courts do not find evidence of voter fraud?
no, it's this specific one.
Just one?
That's what I wrote.
You wrote courts.
No, it's this specific.
So you're saying that even though courts is plural, you meant to say this one court.
They put the apostrophe.
Ah, that's what it is? So it meant you were, you,
Courts means apostrophe specific to the grammatical error.
Mrs. Burden was aware that the courts, apostrophe S, did not find evidence of voter fraud. Okay, do you think that the judge that reviewed, assume the judge read every word very dutifully, which I'm sure he or she did. Do you think that the judge knew that you meant apostrophe S?
Objection, speculation.
Well, Your Honor, this really goes to credibility. This is the person who is providing the facts to the magistrate judge who authorized charges in this case that you are deciding whether to bind over. And that magistrate judge, I suggest, was at least slightly misled by this use of.
Well, I don't think he can testify as to what the magistrate believed when she read these affidavits, but you could question him about whether he believed that clerical error changed the meaning of his affidavit.
Do you believe that the clerical error that you just pointed out changes the meaning of your affidavit?
No, like I said, my writing here is specific to the court that she posted. So it doesn't change, does it change the meaning for me? No, it doesn't change the meaning. I'm not trying to make things up here. I'm not trying to suggest that there was multiple courts. I've laid out the court.
The question wasn't, does it change the meaning for you though?
Oh,
You weren't writing for your own purpose, you were writing for another purpose. And do you think that leaving that apostrophe, there's a reason why there's supposed to be apostrophe?
yes.
Does that change the meaning of the language that you put in your affidavit?
I suppose somebody can interpret it as that.
Do you think it changes it?
No, I don't.
So if you read a document that states a plural, courts to me means more than one court. Do you agree with that?
Yes, but the magistrate also has the ability to give me a call or send me an email to seek clarification on it as well.
Did she, or is it a he or she?
It was a she.
Did she?
I don't recall, but if she would have, it would have been pointed out and addressed, just as we're talking about it right now.
But you have no memory that she did.
I do not. I do not recall.
And if, just from my perspective, if you read that sentence, and I want you to do it real quick, read that sentence with an apostrophe.
I just did.
Does it work? Mrs. Burden was aware that the courts, apostrophe S, did not find evidence of voter fraud. It's not possessive to the court. It just doesn't, what your testimony is doesn't make sense grammatically. You agree with that?
I would not.
So you think, in context, reading the word, that sentence with an apostrophe S makes grammatical sense to you.
That's my understanding.
That's your testimony.
Yes, that's why I'm telling you it's my understanding. Yes.
All right, I'll retrieve that. Your Honor, I'm again moving to another area, so I know it's noon, I'm happy to keep going. Just want to know the board's pleasure.
Just in between the lunch and tax.
Okay. Okay, you testified previous, oh, you know what? Just real quick, because I forgot to mention, I wrote it down, the McBroom report, you mentioned that in conjunction with testimony about Mike Shirk. Yes, that McBroom report came out in like, I'm gonna guess here, June of 2021, that's a, yeah, certainly well after December 14, 2020.
Yes,
When was it, do you know?
I don't.
Does June 2021 sound about right?
It sounds about right.
And that's the document that really analyzed the allegations of voter fraud that were going on, right?
Yes.
And came to the conclusion that they were insufficient to overturn the election. There.
Yes.
But that again was, let's call it 6 months after People's Exhibit 14.
Yes, but Mr. Shirky must have had some additional information prior to that document coming out, because like we just talked about, so he didn't feel that there was any evidence of voter fraud that would overturn the election before December 14th.
Do you have any evidence that Mike Shirky spoke with Kathy Burton prior to 14?
I do not know.
Okay, you testified earlier about the fact that you reviewed the Ingham County prosecutor, Mr. Stevens' memo, correct?
Yes.
Are you aware that that memo was drafted essentially after analyzing the evidence and the facts of this case?
Clarify that.
Sure.
So because, you know, the timing of all of this, you know, by the time I took on the case in 22, late 22.
Yeah. So that's fair. But you weren't, let's be fair, you were not involved in this case until December of 2022, okay?
Yes, sir.
All right, so I'm asking about things that happened in March of 2021.
Okay.
And I'll see if you're aware. Are you aware that the Attorney General's office basically tried to shop this case to the Ingham County Prosecutor's Office?
No, I was aware of the fact that it was reviewed by the Ingham County Prosecutor's Office.
Are you aware that they reviewed it per a request from the Attorney General's office?
I'd have to go back in my notes if there was any sort of request in the records management.
Let's get a little more specific. Are you aware that Assistant Attorney General Richard Cunningham asked Ingham County Chief Assistant Prosecutor Mike Chattelton to review this case back in March of 2021?
I don't recall that.
Are you aware that in that email that Mr. Cunningham sent to the Ingham County Prosecutor's Office that he said it appeared that a forgery took place?
To hearsay, the witness has already said he's not aware of the request by the Attorney General, the Assistant Attorney General, to the Ingham County Prosecutor to review it. And there's no foundation that it would have been privy to this email, and even if he wasn't.
That's fine, Your Honor. I'm going to ask that I allow this witness to refresh his recollection on discovery that was provided in this case that he may have reviewed.
What are you refreshing his recollection about?
I am refreshing his recollection whether he is aware that the Attorney General's office asked the Ingham County Prosecutor's Office to investigate facts of this case.
I don't believe he needs his memory refreshed. He said he wasn't aware of it, but not that he was wrong.
Well, I'm asking him based on his investigation, documents in his investigative file that are produced in discovery in this case, whether he's reviewed the document. And perhaps, again, amongst the thousands and thousands of documents that are in existence, he may have forgotten this particular one. And so I'm asking him to review it. And if it doesn't refresh his recollection, then I'll.
Was that just published to the board?
It wasn't even on the exhibit. It's supposed to be an exhibit.
Not yet. I'm gonna refresh it, sorry. So does that, let me ask, did you have an opportunity to review that document? Oh.
Just want to make sure, I don't see mine anymore. Yeah, so. Dated.
So reviewing that document, refresh your memory at all about the topic of the Attorney General's office asking the Ingham County Prosecutor's Office to investigate this case.
Again, I was aware that the Ingham County prosecutor took a look at the case and reviewed it. Does that answer your question?
So I guess you just don't know how they came to review it.
No.
And that email doesn't refresh your memory that it was the AG's office that asked.
I don't recall seeing.
That never came up in any of your discussions and team meetings or anything about this APA Stevens memo.
No, that memo, no.
Do you have any knowledge about the Attorney General's office trying to get the U.S. Attorney's Office for the Western District of Michigan to investigate this case? Never heard that?
No, I'm aware of it, but it's specifics, no, I don't have any specific.
You are aware of that?
The fact that our office may have had some sort of communication with somebody on the federal side about this case. What that communication was, I don't know.
May have had or did not?
May have had,
How'd you learn that?
probably from my boss.
And fair that there's no criminal case pending in the Western District of Michigan against Kathy Wood?
I'm not aware of it.
You mentioned a guy from the National Archives named David Stupar, right?
I didn't mention
Oh,
that
do you know-
today. No, I mentioned, this is Chartier that I had been in touch with the National Archives.
Was David Stupar one of the guys you were in touch with? I think?
Yes,
When he found out that the case was with, at least being looked at by the U.S. Attorney's Office for the Western District of Michigan, did you know that he sent an email stating that he wanted to quote unquote lobby
Objection,
for
Your Honor.
prosecution?
Hearsay.
This is not hearsay.
I want to know if he's aware of it and whether that
What is
impacted
the purpose of being conflict?
because, well, I want to know how it is that people get to lobby for prosecutions.
I'm sorry, is that a legitimate purpose for this to be on?
If, look, Your Honor, this case, these facts were investigated by the Ingham County Prosecutor's Office, declined. The Western District of Michigan, U.S. Attorney's Office, declined. There's pressure coming from Washington, D.C. through a request, which we have an email, where somebody in D.C. is lobbying for a prosecution. And then,
I'm not disputing any of those things. The objection was hearsay. You said you're trying to figure out how people can lobby for prosecution. That's not a response to a hearsay objection.
it's the effect on this witness, you know.
How can if there be an effect if he's never seen the email?
I want to
Not
know,
aware.
I want to know if he's aware of anybody lobbying for prosecution in this case.
You can ask that. That's not hearsay. The objection is stay.
Are you aware of people lobbying for a prosecution of this case? Did David Stupar attempt to lobby for a prosecution?
no, not to me, he did not, and we never had any sort of conversation about that.
In your investigation, did you see the email dated? Anyway, did you remember reviewing an email that David Stufar sent saying you wanted to lobby for a prosecution?
I don't recall. See,
Um, There's also in the discovery letter from some civil attorney named Bradford Springer. Sends a letter on January 10th, 2023, before charges here asking for.
Objection, you're on hearsay.
Well, I want to know if he answered it.
Are you reading the email into the record first?
No.
It sounded like that you were supposed to do though.
No, and so are you aware of somebody, a civil lawyer who was going to file a civil case based on these facts? His name happens to be Bradford Springer, asking the Attorney General's office for information about the electors so they could serve their complaint on these electors. Did you coordinate your investigation with civil lawyers?
what do you mean? Coordinate? I mean, when I reached out to interview your client, I received a call back from Mr. Arrington. Is that what you were referring to?
No, but that would be a criminal lawyer.
Yes. They do all types of practice law, but I'm not sure what you're asking.
Did you in any way coordinate your investigation with civil lawyers who filed a civil complaint alleging similar things to this case? Did you coordinate your investigation with them?
No, we're not both doing civil.
Did you share information about these 16 electors with this civil lawyer?
No, I did not share.
Just for my clarification, civil lawyers where?
Yeah.
So there's a gentleman named Bradford Springer. I believe he's involved and there's a civil lawsuit, essentially a parallel civil lawsuit. And in January of 2023.
Well, my question is, a civil, because you say a civil lawyer, that be someone from the civil litigation department at the AG's office. I don't know what you mean.
That's fair. That's fair. What I'm trying to get at, sir, is we have a letter from a private civil lawyer who has filed a civil case against these same 16 individuals. Okay, let's stop there. Are you aware that there's a civil case?
In Kent County, is that the case you're referring to?
Yeah, yes.
I'm aware of that case, but that was filed. It's filed a long time.
Probably around January 2023.
No, it was, as I remember, it was in 2022. The case that I'm referring to, I think it was filed in 2022.
Are you aware that somebody involved in that case named Bradford Springer was contacting the Attorney General's office asking for information about these 16 electors, their press, contact information, things like that?
No.
And your testimony is you didn't share any information with private civil lawyers.
No.
Are you aware if anybody in the Attorney General's office shared any information in response to that?
No.
Would you agree with me that the memo that Ingham County Prosecutor APA Stevens drafted essentially determined that
Objection, Your Honor. Hearsay.
well, so, and I'm going to ask the court if this is okay to do, I'm going to ask a bunch of questions about statutory language, but there is some information that's in the memo that I think is helpful. And since this witness testified that he viewed this memo, I believe he said prior to the charges being brought here, although we'll clarify that. I want to know if these things impacted his decision.
Well, I think you can ask him if that will impact his decision without getting into the specifics of the memo. I mean, getting into what was specifically stated in the memo was the hearsay issue, not whether or not that memo in and of itself affected his decision.
But I think there's various aspects of the memo that I want to get into with him, whether those things impacted his decision,
I don't know how you do that without you're saying.
because it's the effect on him. It's how does it impact him? He's the lead investigator here. So I'll try to, well, why don't we do it one question at a time?
Okay.
Your Honor, may I just join in as a response to Mr. Danini? The other impact would be Agent Schock said he's the one who actually did research on statutes, both federal and state. And so if there are statutes where there's a contrary conclusion in the Ingham County prosecutor's memo, I agree with Mr. Danini, that does go to the effect on Agent Schock.
I can understand that, but if he's asking about whether or not this agent was aware of statutes, that's one question. He's asking about a memo, which this agent is not testified. He wasn't really aware about the memo. He didn't read the memo.
No, I don't think so, Your Honor. I think I'll ask him that question.
You can.
Did you read the APA Stevens memo?
Yes, sir.
Oh,
And did you read it before your affidavit that authorized charges in this case?
Yes.
so you want to ask him as to whether or not the statutes referenced in that memo affected his decision?
Yeah, but I'm gonna do it in some.
I know you want to take the scenic route.
Yeah,
Object to the rule.
thank you. Okay, let's take a look at the statutes a little closer here. You know, we've spent a little time on it, and I think we need to dive into it. Forgery is one of the charges you authorized, well, that your affidavit authorizes here, right?
Yeah.
And you testified that you did research about the forgery statute.
What's printed on the affidavit.
So you just copied and pasted the forgery statute into your affidavit?
No, I mean, the MCL. So just read the statute.
Okay, you read any cases about the statute?
They printed the cases that have been, I don't know what you're asking.
Are you talking about case law?
No, I didn't read the case.
I know you're not a lawyer, but you're aware generally that there are laws and then there are cases where judges may interpret the law, fair?
Yes,
Okay, so it's your testimony that you were focused on the statutes, not the cases interpreting the statutes. Is that fair?
yes,
Are you aware that forgery is a property crime under Michigan law?
I would have to look again at it.
You have to look again at what?
The statute. Or any related materials that say that it's a property crime.
All right, let's do hopefully a simple one. I'm handing the witness what's been marked, or excuse me, hasn't been marked, just a copy of MCL 777.16N. And ask that the witness look at that. Your Honor, I don't intend to introduce this. I think the court can take judicial notice of it.
The statute.
Yeah. They were all just telling you
Yeah.
property.
I'm just gonna pull it up anyways.
You see the second line that says 750.248 is the forgery statute, and it's classified as a property crime, class E felony.
Yes.
So we've established that this is a property crime. That means somebody has to be defrauded out of property, fair?
Objection calls for legal conclusion.
Did you want to respond to the objection?
I don't think it's much of a legal conclusion to say the forgery statute being a property crime means somebody has to be defrauded out of property.
What? No, did you want to make a statement?
Well, I think that is an oversimplification of what the statute actually says. It doesn't just say like what we would think of as the general sense of property.
Well, I think what calls for a legal conclusion is what is property. I don't
Right.
think him reading the actual elements of what's stated as a criminal investigator and the person who charged it said that there was probable cause that these individuals committed these acts. I think he can state whether or not he believes that the statute requires the defrauding of property. I think he can. He just can't define what property is.
I mean, we can see that it was a property.
So then there's no objection. You can answer the question.
Yes.
Now, when you read the Stevens memo on forgery, are you aware that he came to a different conclusion than you came to about these facts rising to the level of a crime under the Michigan forgery statute?
Well, my conclusion was based on the information throughout my investigation. His conclusion was based on the review of the information he had at the time. So does that answer your question?
Kind of, but it's a little, my question's a little different. So in fairness, you reviewed more facts than he did. Is that what you're saying?
Yes, sir.
Okay, but you're aware from your review of his memo that as to the forgery statute, his review was in conflict with your conclusion that forgery was met. There?
I have to review specifically what he said in that memo. Because again, I told you that I reviewed the memo, but I don't recall specifically what he said.
All right. But you're aware that his conclusion was that the forgery statute was not met here based on his review of evidence at that time.
I'm aware that they declined, or he declined to authorize charges.
Which is in conflict, is contrary to your decision, right?
Yes, I don't have the decision to authorize charges.
You ever submit an affidavit to a judge and the judge said, no, I'm not going to authorize charge in your years of being a police officer?
I don't recall.
Have you, when you looked at the forgery statutes, are you aware that forgery occurs when somebody makes a false written instrument for either a pecuniary gain or exposes someone else to a financial loss? In your investigation and your research of the law, did that come up in your research?
Yes.
Are you aware that there is no property interest in an elected office?
I'm not aware of that.
Do you think there is a property interest in elected office?
I don't know. I think to answer your question.
Is it fair from your investigation that no property was taken in respect to this case?
You mean stolen?
Yeah.
No, there was no property stolen.
Do you agree that Ms. Burton received no financial gain?
Yes, I've already said that. I didn't see that. I didn't come across any evidence to show that she received any financial.
And it is a little duplicative, but you answered that question for with respect to another individual, so I want to make sure I asked it first. Okay, let's turn to election law forgery. That's MCL 168.933A. Are you aware that the Ingham County APA Stevens memo determination was that those elements were not present here? Are you aware of that from your review of that memo?
I don't recall. Again, it was not.
But they declined, correct?
Yes.
And they analyzed the election law statute, fair?
I don't know what they did.
You read the memo.
At some point,
Understood.
can we get to the effect on the listener?
Yeah,
I know.
where it's all the effect on the listener.
I've yet
He's
to
asking,
get-
was he aware? I mean, I think there's a buildup. He said he was gonna take the scenic route. I said I will allow him, so I don't know how long this memo is. I think it was attached to one of your motions previously, so I have seen the memo. But I can't tell you how long, so he's gotta get to all the staff to get the memo. Before he gets to the effect.
Yeah, and I mean, I'm happy to, I can refresh his memory, we can look at it together. I will object to both of the assistant attorney generals arguing with respect to 1 minute. I think they gotta choose.
That's in the court's discretion. Sit down and talk. Here's the thing, okay, Your Honor. So this entire line of questioning only becomes relevant if Special Agent Shock says one thing, and that is, I read that memo and it had some kind of effect on me. So while I understand the court's previous rulings and statements on that, I think the court also has the discretion to ask that question first. We do not have to take the scenic route if that memo had no impact whatsoever on what Shock did. So I would just ask that the court exercise some discretion in that regard and have Shock answer that question first.
We already have one of those, which is he read the memo. Now, whether or not the memo in its entirety had any effect, I think that goes, I mean, that could be loaded. So I think what, and I could be wrong, I think what Mr. Giannini is trying to establish is how each of the statutes stated there had an effect on his decision.
I agree with the court entirely. And so if he says that, if the answer to that question is the memo had some sort of effect on me, absolutely, let's drive the scenic route together and ask all of those details. But the court has full discretion to have him answer that question first. Did it have any effect on your decisions in this case? And if he says yes, let's all drive the scenic route together, however long the court wants to give for that. But if he says no, we can move on.
Did you want to talk?
Yeah, I like 17-mile drive, and I'm gonna ask the questions that I wanna ask, unless the court tells me I can't ask them, not the AG's office telling me.
Again, my understanding of where you're going with this is that, because I could foresee him saying, yes, it had an effect, or no, it didn't have an effect, but that doesn't, because he's not gonna recall exactly what's in this memo. What specifically in this memo was the effect? So it brings us back here, even if he says no, it had no effect, that doesn't mean that he didn't review any one of these statutes and that these questions he's asking them won't be relevant to where he's trying to go.
Those are different questions, Your Honor. I agree with the court entirely. I'm just trying to move this along because it all started because we were going that route of effect on listener. So if there's no effect on listener from the memo itself, then by all means, ask about the statutes in general. That's a different line of questioning. I'm simply trying to close this down in terms of that is all. And it is much less an evidentiary objection and much more just a friendly suggestion in terms of judicial economy. So if the court doesn't like it, I'll gladly sit down.
This is what, day 6 or 7 of half of a preliminary examination.
Yes, Your
We haven't rushed this long, we can't start rushing now.
And Your Honor, and I respect Ms. Chartier, I want her opinion too, but let me, if I may, since I'm standing. You started this proceeding with an admonition. We're gonna this criminal case involving 8 felonies, some 14-year felonies. We need to take this seriously. I'm taking this seriously. And if I want to take the scenic route, as long as the court indulges, and I think it's in fairness to my client that we do that.
And also, it sounds like the court is allowing the questioning, but it also goes to impeachment. With all due respect to Agent Shock, a lawyer, a seasoned prosecutor, wrote a detailed memo with statutes and case law analyzing each and every charge. And if the agent is saying he reviewed it and it had no impact on him, when he's saying all the research he did was just pulling up the statute and that's it, I think that absolutely goes to how this investigation starts and then how it has rolled to the point where we are 15 people faced 8 extremely serious felonies.
You can continue. No objections on it.
Okay, election law forgery. Let's try to dig in a little bit there. Are you aware that that was recently passed in 2018?
Yes.
And even the predecessor statute, which is MCL 168.937, that was only prosecuted 2 times. Are you aware of that?
No.
Okay. I know you said you didn't look at cases. I just want to make sure. One of those cases was People versus Pinkney. Are you aware of People versus Pinkney?
No.
Did you read that case?
No. No.
Did anybody explain it to you?
No.
About People versus Hall?
No.
Again, same questions. Nobody explained that case to you?
No.
So you have no idea what those cases were about?
No.
Would you agree that nobody was tricked or fooled by the alternate Republican certificate of votes, which is People's Exhibit 14? Do you agree with that statement?
We was tricked or fooled by the certificate of votes. A little clear.
Okay, let me ask you, if you read in the APA Stevens memo where he says, whether the Republican candidates were grandstanding or preserving their rights, nobody was fooled by their transmitted certification of votes. Do you remember reading that?
I don't, but as you just read it,
Do you disagree with Mr. Stevens' conclusion?
I do. That's why I presented. Yeah.
Did you notice where he said preserving their rights in the memo?
Yes, but you have to understand that when Mr. Stevens crafted that, again, it was based on the information. There wasn't all these interviews that were done leading up to the July 2023 charging.
Mhm.
So there was very little information that I saw that, where interviews were done or information or evidence was gathered and things like that. So, yes, I disagree with it because while I respect it, it was written at a time in a place where maybe he had a certain amount of information in front of him. He wrote that based upon the information he had in front of him. Again, through my investigation, I wrote that affidavit based on the information that I had in front of me.
Okay. And you testified to that already. You had more facts than he did, right?
Yeah.
Because you investigated for a longer time, right?
Yes, but I didn't see his investigation. I didn't see that whatever was done with it.
Okay, let me see if this impacted you in his memo. It says,
I just have a quick question.
oh, sorry.
You say you didn't see his investigation?
Yes. I didn't see, I saw his memo, but I didn't see, like where an investigator was assigned to it, whether it was a special investigator from the county prosecutor's office and had done a preliminary investigation. Again, as I stated, I took over the investigation from Special Agent Cronin, in which I saw his investigation, but all I saw was the charging memo by Mr. Stevens.
Okay, but are you aware of whether or not there was an investigation that Mr. Stevens relied on?
I'm not aware.
So when you made the statement that you had more facts than he did, you're not aware?
Right, yes,
Okay.
so, yes, and like I said, I wasn't certainly trying to second guess his investigation at all. I'm not aware of the facts or any investigation that may have been completed by Mr. Stevens or his staff that, brought him to that conclusion. Does that help?
I want to know if this impacted your investigation at all and the conclusions you reached in deciding to submit your affidavit. Mr. Stevens states, quote, the Republican candidates transmitted the certification of votes to satisfy their obligation under federal law if they became certified electors. Close quote. Do you recall reading that in the memo?
I don't recall the specifics of it.
Did that impact in any way? You may not recall the specific that I read. I can hand you the memo to verify it. But did that impact the way you proceeded in your investigation, knowing that this prosecutor is talking about obligations under federal law if between December 14, 2020 and January 6, 2021, they became the certified electors?
Yeah.
Did that impact your investigation?
Yes.
Pretty sure this is the first prosecution under this forgery, this new forgery statute. Are you aware of that?
Didn't you just mention there was two other?
On the old statute.
Oh, okay, no,
You're not aware that
I'm
you're
not aware.
blazing new ground here?
No.
Are you aware that one of the elements that has to be proven under the Michigan election law statute is that the allegedly false document, was Exhibit 14, has to relate to some purpose under the Michigan election law?
Yes.
No, the problem there too, right? Isn't the certificate of votes something that's required under federal law?
Yes, there is a certificate of vote which is required under federal law.
Not state.
Well, yes, I'd have to go back and review some of the state statutes, but I believe the state statutes, I'm familiar with the one that's just off the top of my head, which require them to convene at certain places. But in order to completely answer your question, I have to, do some more data.
That's fair. You can dig. So let's just go through it. 3 USC section 9 explains how presidential electors cast their certificate of votes. Are you aware of that?
Yes.
3 USC section 11 provides for the process of how the certificate of votes gets delivered to the president of the Senate, National Archives. Are you aware of that?
Yes.
Now, what you just testified to is kind of the mechanism for the electors to vote and where they vote and process under state law, right? But state law doesn't talk about the document, the certificate of votes, does it?
Again, I'd have to refer back.
When you read the APA Stevens memo and he states, quote, the certification of votes is required by federal law, not Michigan law. Did that have an impact then?
Like I said, this might be the fact that the entire document.
The APA Stevens memo impacted you.
Yes. It's just like any other piece of evidence or information that I'm across in the course of the.
I mean, you have another prosecutorial entity saying, ain't no crimes here, right?
Yes.
And so you got to overcome that.
Well, again, it may be based on information that he had, but the information that I had at the time was very limited.
All right. Another element that the prosecution must prove in this case is that Kathy Burden acted with the specific intent to defraud, right?
Yes.
Are you aware that the APA Stevens memo concluded that, quote, there is not any evidence that proves this evidence?
Yes.
And he calls it nothing more than a quote unquote political stunt, right?
I don't recall what he said.
Do you remember him quoting Professor Friedman, who's a University of Michigan law professor and constitutional law expert, who said that the quote Republican elector votes have no legal authority? And are you aware that Professor Friedman's statement goes on and states there's nothing preventing any group of 16 people from getting together, saying we're electors, but it doesn't have any legal force? Do you recall that? Now, Ms. Chartier asked you some questions about the Attorney General's public comments about this case. Do you remember that?
Yes.
And there was that brainwash comment, right?
By Mrs. Chartier?
Oh, well, no, Mrs. Chartier was
She was
recounting Ms. Nessel's
Yes.
comment
Yes.
about how the people who are charged in this case have been quote unquote brainwashed, right?
Yes, I recall that.
And that they really legitimate believe and genuinely believe what they did, right? Basically, remember that?
Yes.
And the last thing she said was, somebody can't even plead guilty if they wanted to, because they can't admit what they did violated the law because they still think they're right. Right? Remember that?
Yes. I remember talking about that. As far as the specifics of what was said in the video, I don't remember the specifics, but
And we already established that this is a specific intent to crime.
yes.
How can someone genuinely believe something and yet have at the same time knowingly commit a crime to do that very same?
I guess the question.
I am. If somebody genuinely believes something, how can they do something knowingly wrong?
Well, I mean, if you believe that you walked into a bank and believed that money was yours, and you decided to say to the clerk, hey, give me the money, took the money, I don't know, you're calling upon me to create like some imaginary scenario, so I'm trying to do that and answer the question. Is that?
Yeah, let's use your imaginary scenario. If I went into a bank teller and said, and I genuinely thought that was my money, and I took it, am I guilty for knowingly taking money that didn't belong to me?
Or your ignorance of the laws?
No excuse. Still negates my specific intent, Mr. Shah. Are you aware of the federal indictment against former President Trump that's pending in Washington, D.C.?
Yes,
Did you review that indictment?
yes,
I want to know if you reviewed paragraph 10B, which states that I think it refers to some of the electors, quote, were tricked into participating based on the understanding that their votes would be used only if Mr. Trump succeeded in outcome determinative lawsuits within their state. Do you recall seeing that in federal indictment against Mr. Trump?
I don't.
Do you see how the special prosecutor, Jack Smith, is saying that the Trump campaign tricked many of these alternate Republican electors?
Yeah. Reject. Here's that. It's definitely being used for the truth of the matter asserted.
No, I want to know if it impacted him. Does he think that some of these electors, Ms. Burden in particular, was tricked into signing a document on December 14, 2020?
That wasn't your question, though. It's your question.
Okay. So you already said you read the indictment, and we talked about the specific paragraph 10B, which refers to alternate electors across various states, right? Want me to read it again?
Yeah, just
Let me do that.
confused here. So we're talking about the Jack Smith.
Jack Smith, that's right.
Okay, and so I recall reviewing it. I don't recall specifics about it. It's been quite some time.
Let me read it again.
Well, Karen, I'm going to object because it's still hearsay and it can't qualify as effective to listen to because first of all, the indictment came down after these charges were already done. So it can't be something that this investigator took into consideration when drafting this affidavit.
Your Honor, that may be fair, but I would hope that this investigator and this investigation team, if they are continuing to investigate after July of 2023, which is when these charges were authorized, which he's testified clearly he is doing on a daily basis, that they would take that information into account and maybe change their trajectory.
So are you, this is being offered for the effect of the listener and not for the truth of the matter, so is what you're stating?
Do you think that Kathy Burden was tricked into participating on December 14, 2020?
No,
Do you see where this indictment says that the electors, at least some of them, were tricked into thinking that this would be used only if something changed after December 14, 2020 and before January 6, 2021?
I'm sorry.
You've heard testimony in this case. That's exactly what many of these people knew including Ms. Barton, as to the continuing nature of this document. Didn't we? That the People's Exhibit 14 was a document that was contingent on future events occurring, specifically within that 8-page. Right?
Yes, I heard that.
You heard people that you interviewed tell you exactly that, right?
Yes.
You heard the drafter of the document tell you exactly that, didn't you?
Yes,
And that's Mr. Chief.
yes.
Your search warrant affidavit, paragraph 23 states, quote, "The candidates for elector and the Michigan GOP leadership knew prior to their meeting on December 14, 2020, that there was no legal reason to create an alternate slate." Close quote. Right?
Which affidavit are you referring to? The search warrant for, there was many of them here, so.
I think it's in two places, so I got this one. I'll just- Well, let me, well, instead of- 27. Permission to.
Yes.
Why don't you identify what I handed you and make sure I get it right?
Affidavit of probable cause.
Okay, let's look at paragraph 27. That's what I just read from. I want to make sure that I read it correctly into the record.
Yes.
Okay, and that is, so, sorry, that's the affidavit of probable cause, and that is dated what? Just so the record's clear on what I handed.
7/18/2020.
Okay, so on July 18, 2023, you wrote that statement, right?
Yes.
Or maybe a couple days before.
I was gonna say maybe a day or two before.
Very good. And that's paragraph 27, so that would be one of the ones that you authored on your own without assistance from the Attorney General's office.
Yes.
Or they might have. Did you say they, I forget, did you say they didn't or did maybe edit those paragraphs?
I don't recall that.
Fair enough. But that's essentially your section, right?
Yes.
And you, again, the quote is that prior to the meeting on December 14, 2020, they knew that there was no legal reason to create an alternate slate of electors. Did I read that correct?
Yes.
All right. Now, in fairness, you didn't interview Mr. Cheesebro until well after this, right?
Yes.
Mr. Cheesebro told you the exact opposite of that sentence, didn't he?
Yes.
He told you there was a legal reason, right?
Yes.
In fact, he told you that he believed there was plausible litigation that might be won between December 14, 2020 and January 6, 2021, when he drafted those documents, right?
Yes.
Do you remember and I'm not gonna get into it a lot, but that Attorney General Nessel, when she got on TV and talking about this case one time, tried to dismiss the relevance of the 1960 Hawaii situation.
I don't.
At a minimum, we know that you knew about that case and looked at it and pondered it prior to the affidavit you filed, right?
Yeah.
Your Honor, I'm about to go into that. I'm happy to keep going.
About 1 o'clock. I think bare minimum, people have to get a bathroom break, so we're gonna be adjourned for an hour. I should be back here at 2 o'clock.
Electoral College votes from Hawaii?
Yeah.
And you're aware that Democratic candidate John Kennedy challenged that, correct?
Yes.
Eventually, President Kennedy was awarded the 1960 Electoral College votes from Hawaii, right?
Yes.
And are you aware that the governor of Hawaii originally sent a certificate of ascertainment in favor of Mr. Nixon and consistent with the Republican certificate of votes?
Excuse me.
Very close to January 6th of 1961, Hawaii governor sent a new certificate of ascertainment in favor of the Democratic certificate. You aware of that?
Yes.
And fair that new certificate of votes happened after the statutory date set for the electors to gather and cast their electoral votes. That year was December 19th, 1960. You aware of that?
I don't recall it. I may have reviewed it.
So, just to summarize, so we're all on the same page. There were two certificate of votes submitted on December 19th, 1960, right?
Yes.
A Republican slate, which would have been the official certificate of votes as of that date, right?
As of December 19th?
Correct.
Yes.
And a Democrat or alternate slate that was contingent, a contingent certificate of votes as of that date. Yes? Maybe that was an inartfully stated question.
Yeah.
Sorry. Let's look at it.
May I approach on?
Yeah. I'm gonna hand you what I'm marking as proposed defense exhibit D. Is it E? E. Excuse me.
What did you say?
E. You recognize the document I just handed you?
Yes, I don't recognize the envelope. Copies of the envelope.
Okay, so there's 5 pages to the document I handed you, correct?
Yes.
The first 2 pages are the actual certificate of vote, the Democrat contingent certificate of vote, right?
Yes.
See where it says at the top,
Yeah.
Democratic
Yeah.
electors?
Yeah.
Okay. You see at the bottom, it says the person voted for John F. Kennedy.
Yes.
All right, and that document is signed by 3 individuals and is dated. No, it's dated December 19th, 1960. And it's at the end of the end of the first paragraph on page 1. Fair?
Yes.
Oh. Okay. Let's take a look at this document. So again, this one, the vote as of this time, when this document is created, was in favor of Nixon, correct?
No, in favor of Kennedy.
The actual vote. So the vote count as of December 19th, 1960 was in favor of Richard Nixon.
Oh, yes.
So this document was signed, proposed defense exhibit E was signed by Democratic electors when their candidate had not won the election. Fair?
Yes.
Let's look at the language. Do you see at the top in the first paragraph where it says that these 3 Democratic electors were both duly and legally appointed and qualified?
We're gonna move to make this document before we publish it.
I would love to move to the document.
The objection to the admission of the document?
No.
Document, defense exhibit E is admitted.
Would you like a copy, Ron?
Yes, please.
you see at the top of Defense Exhibit E, where it says that these 3 Democrat electors were, quote, duly and legally appointed and qualified by and for the state of Hawaii, as appears by the annexed list of electors made, certified, and delivered to us by the executive of the state. Do you see that?
Yes.
Were these 3 Democrat electors the duly and legally appointed and qualified electors for the state of Hawaii on December 19, 1960?
It appears so.
Okay. And as of December 19, 1960, would you agree that the executive of the state of Hawaii is the governor of the state of Hawaii?
Yes.
Did the governor of the state of Hawaii deliver to the Democrat electors on or before December 1960 a certificate of ascertainment declaring them to be the electors for the state of Hawaii?
I don't recall that. It's the certificate of ascertainment with this.
It's not?
I don't recall that, so that, I don't recall.
Okay.
If they get.
You don't recall that we just went through it before, and I know you said you didn't have the date, but that the governor of Hawaii issued a revised or new certificate of ascertainment in favor of John F. Kennedy on January 4th, 1961.
Yeah.
Are you aware of that?
Yeah.
Okay. So if that's true, the governor of Hawaii issued a certificate of ascertainment to the Republican electors in Hawaii before December 19th, 1960, right?
I don't recall the specific date, but yes, I know that they delivered those.
Okay, and then it changed, but something happened after December 19, 1960, right?
Yes.
The election, it flipped in favor of President Kennedy, right?
Yes.
You're aware of that.
Yes.
So a new certificate of ascertainment was provided by the governor of the state of Hawaii in favor of the Democratic electors, right?
Yes.
So my question is, on December 19, 1960, did these electors, these Democratic electors who signed Defense Exhibit E, have a certificate of ascertainment declaring them to be the duly appointed and qualified electors for the state of Hawaii?
Well, the certificate of ascertainment was provided by the governor.
After December 19, 1960.
Okay, so what, I'm just not clear about what you're referring to.
If the Democratic electors did not have a certificate of ascertainment from the governor of Hawaii on December 19, 1960, could they have been the duly and legally appointed and qualified electors as of that date?
No.
Did they file and sign a false document back in 1960?
No.
No.
They didn't, because they had the certificate of ascertainment.
They didn't. That's what I'm telling you. They only had a certificate of votes. The certificate
Are
of
you
vote.
telling him or are you asking?
Right.
Did they only have the certificate of votes as of that date?
I don't know because I don't have all the material here in front.
Well, we're gonna have to focus a little bit because you know the history. So we're gonna go through it real slow. All right. On December 19, 1960, right? Do you know the significance of that date?
I'm not familiar. Well, yes, I do know the significance of the fact that they gathered and signed a document on that day.
That is the statutorily required date for electors for the president of the United States to vote pursuant to federal law and constitutional law. Are you aware of that?
For Hawaii or in general?
In general. And that can be different dates. So in 1960, it happened to be December 19th.
Understood.
In 2020, it was December 14th.
Okay.
Because it's something like the third Wednesday after the second Monday or whatever the language is, right?
Yeah, so that's where I was getting confused about what you're talking about.
Okay, so now let's focus. In 1960, December 19, 1960, that's the date that the electors had to vote, correct?
Yeah.
Okay. On that date, President Nixon was ahead. He was the one who was declared the winner of the state of Hawaii as of December 19, 1960, correct? Yeah. The governor of Hawaii, prior to December 19th of 1960, issued a certificate of ascertainment naming Republican electors for the state of Hawaii as the duly appointed electors for that state, correct?
Yes.
Okay, now, something happened after December 19th, 1960, that changed the results of the election. Are you aware of that?
It's my understanding the electors met together.
Okay,
The,
hold on.
the Republican and Democratic electors met together.
They did.
Okay. So
I'm
they-
not asking
they-
about
they- I understand that you asked the question, so I'm trying to tell you what I know.
Yeah, but you, well,
So
That's
so
not
they
helpful.
met- So they met together.
well, it's not helpful because you're not answering my question. So you can elaborate, but I didn't ask you who was
Counsel?
together. Go ahead. Oh, sorry.
Yeah, I would ask that the witness be allowed to answer the question. And I know it might not be helpful to Mr. Dooley, but it's still an answer.
Well,
And I would ask that
You
he be
can't
allowed
stop
to
him from
complete his
answering because his answer is not helpful. To the extent he's not answering your question, that's different.
yes.
But if he's providing an answer and you don't like it, that's the risk you take when you ask the question.
No, and it's fair, and we can have the question read back if we need to, but I don't think I asked the question that elicited were they together
The question was, did something happen on or about December 19th?
after.
After December 19th.
Right. That's got nothing to do with whether they were together on December 19th.
I agree.
So, after December 19th, 1960, we've already established the significance of that date, right?
Yes.
After that date, there was a recount, correct?
Yes.
A circuit court judge in the state of Hawaii on December 14th, 1960, called for a recount. Are you aware of that?
Yes.
It was on that day.
I'm aware of the recount. Thank you for providing the data.
All right. And after that date, the results changed so that actually John F. Kennedy won the state of Hawaii. Are you aware of that?
Yeah.
And after that, because clearly that happened after December 19th, 1960, fair? The recount
The recount was before,
was after December 19th, 1960,
was after December 19th.
correct?
Okay.
You aware of that?
Yeah,
All right.
I'm just trying to keep
I
track
know.
of this conversation.
I know.
It's,
All right. And so if that happened after, the governor of the state of Hawaii is not going to issue the new certificate of ascertainment until he knows the votes flipped, right?
yes,
And on January 4th, 1961 is when the governor of the state of Hawaii issued a new certificate of ascertainment in favor of the Democratic slate of electors. Are you aware of it?
Yeah.
All right. So my question is, if, now that we have established that on December 19, 1960, the Democratic electors did not have a certificate of ascertainment in their hands, in their possession. So were they the duly and legally appointed and qualified electors for the state of Michigan on December 19, 1960? Sorry, for the state of Hawaii on December 19, 1960.
they didn't send the document in saying that they were. That document didn't travel to DC prior to January 5th.
January 6th
January 6th.
of 1961. Okay, but I'm not asking you about that. So let's focus. The document itself, you got it right in front of you.
Yeah.
Defense Exhibit E is the certificate of votes. That one happens to be the Democratic certificate of votes, which is a contingent or alternate slate. Would you agree with that as of that time?
Yes, at that time, yes, it was an alternate slate, but they weren't presenting themselves as an alternate slate. Or I'm sorry, as the electors, they were presenting themselves, as my understanding, as the alternate slate.
Fair. But let's look at the face of the document, okay? I just read it. Let's read it again. First paragraph. These three Democratic electors were, quote, duly and legally appointed and qualified by and for the state of Hawaii. Let's stop there.
Yes.
On December 19, 1960, is that a true statement?
It's a true statement based on the information that you provided. I mean, I wasn't back in 1960, so I'm basing that response on the document that you provided.
Basing what response? I don't think I've heard a response. yet.
Yeah, I said it's a true statement.
It is a true statement.
Yes, I just said that.
Okay, so on the face of this document, Defense
That's
Exhibit
what
E,
it said.
Defense Exhibit E, it's your opinion that this is a true document as of the date it was signed, correct?
I don't know what a true document, what kind of true document it was at that time. What I do know is what I'm reading in front of me, which is presented to me now. What it was back at that time, I can't answer.
No, you're gonna have to answer, with all due respect. So let's focus. People's Exhibit 14 was essentially Ken Chesbro, when you interviewed him, told you he used the 1960 Hawaii precedent as an example when he drafted the 2020 alternate elector certificate of votes, didn't he?
That was part
But he used that as an example, right?
Yes.
All right. And would you agree with me that a lot of the language in People's Exhibit 14 mirrors, we'll look at them close side by side, mirrors the language in this Defense Exhibit E?
a lot of the language,
Yeah.
I'd say some of the language, yes, doesn't,
Specifically, the language that I'm quoting right
yes.
now. Okay. And you have initiated charges, your affidavit has initiated charges in this case because the document, People's Exhibit 14, is allegedly false on its face. True?
Yes.
The falsity is that you say that these individuals, Kathy Burden specifically, signed a false document, right?
Yes.
The falsity is that the document declares her to be the duly appointed elector for the state of Michigan, correct?
Yes.
So what I'm trying to get at with my questions about the 1960 Hawaii document is, why is it false in 2020, but it's true in 1960?
Again, the 2020 case, you know, as I put together my affidavit, was a culmination of facts and information. The 1960 case is different, like I said earlier, the fact that they met together. There was a recount initiated. I was not aware of any recount in 2020. I was not aware of any evidence to suggest that the Democrats, electors, Republican candidates or electors met together to cast their votes for the person in their party.
Okay, people got along a little better in 1960 than 2020, so I'm not sure that how relevant that is. But
Move to strike.
my focus is on the language of the two documents. All right.
Okay.
Okay. The three Democratic electors from the state of Hawaii on December 19th, 1960, said they were the duly appointed electors for the state of Hawaii, and they were not as of that point. Were they?
Not at the time that this was signed.
Right. Okay. All right, we're getting somewhere. So, was it false at the time they signed it?
Yes.
Would you have charged these three people back in 1960 for signing that document?
I didn't hear what you said because you spoke at the same time.
I said, would you have
No,
charged?
she said something. I know she was saying on objecting. I heard your
Oh,
question.
sorry.
I'm objecting for speculation and relevance.
I think it's very relevant, Your Honor. It
The
is
person and
speculation.
what he would have done in 1960.
If he's presented these facts as an investigator who's been assigned to investigate whether a crime has been committed, and he saw that somebody, for his testimony just now, signed a document and it was false at the time. It's the same document. So would he have charged them back then? I'm curious.
In the state of Michigan, obviously, because our laws are not the same as Hawaii's law.
And with all due respect, the facts as have been laid out repeatedly on this record are different.
Well, I think
So-
that if the court allows the question and he answers, he can obviously indicate that,
Yes.
by saying no, and then I'm sure there'll be a follow-up question, and then he'll explain why it's a no. But whether or not he would have charged these people in 1960, based on information stated today, I will allow him to answer that question. You have another question?
I want to answer that
Oh,
question.
okay.
No, I don't have, I mean, all I have in front of me is a document. For me to speculate on whether or not I would charge, again, we talked about this. I don't charge, okay, I gather the facts, we talked about that. You presented me with one document. For me to say that I would charge based on one document, no, I mean, in an investigation, we try to gather facts and information, evidence, interviews. So that's the process that I would use. So to answer your question, again, no, I wouldn't, because I'm only looking at a document, trying to make a judgment call based on one single document, without one single interview, without one single search warrant, or any other physical evidence.
All right. Is it fair to say, now you said that the document they signed was not accurate at the time, so they signed a false document. Did I have that right? In
Who's they?
The Democrat electors on December 19th, 1960.
Yes.
Okay?
Yeah.
Okay. And can you see that while they signed a document that was, at least in the four corners of the document, technically not accurate as of the time, can you see that there was a potential contingency that occurred that could then make that document be a valid document?
Yes.
And that's what happened in in January of 1961, right?
Yes.
So essentially, the Defense Exhibit E, which was not true as of that date, became true after the governor of the state of Hawaii issued his revised certificate of ascertainment. Right?
Yeah.
All right. And then just real quick, I read it, but you see where it says, I was focused on the duly and legally appointed qualified. At the end there, it said, and delivered to us by the executive of the state. You see that? Sorry, it's in the first paragraph, I believe. Yeah, it's in the middle there.
I see it.
Okay, and that too, as of December 19th, 1960, was not true, correct?
Yes.
But it became true on January, if we assume January 4th, 1961 is the date that the governor issued the new certificate of ascertainment, it became true later, correct?
Yes.
Is that kind of by definition what a contingent document is all about?
Yes.
Sir, would you agree with me that there are certain similarities between Defense Exhibit E and People's Exhibit 14?
Yes.
They both say duly elected and qualified electors. Would you like a copy of the People's Exhibit 14 to compare them side by side?
Yes.
I'm handing the witness People's Exhibit 14 and just directing them to page 2 of that one. Thank you. I have an extra. Okay, do you see both say, and again, let's try to go through this pretty quickly, but they both have the words duly elected and qualified electors for president. Fair?
Yes.
And this document doesn't have anything about receiving anything from the governor or the executive of the state of Michigan, right? The People's Exhibit 14.
No.
And I'm going to retrieve those from.
Okay.
Yes. Okay. All right. Sir, you know from your investigation that Kathy Burden didn't orchestrate any of the events that occurred related to the alternate electors on December 14th, 2020, right?
Yes.
You know, she just showed up that day for Stu Foster's request.
Yeah, she did show up.
And if anybody was behind the scenes orchestrating things, it was people like Laura Cox and Stu Sandler on the MRP side, fair?
Yeah.
And Sean Flynn and Mike Roman at the national level.
Yes.
And Mr. Flynn and Mr. Roman were acting at the direction of the Trump campaign.
Yes, and I believe there was more people involved. Obviously.
Sure.
We're just not mentioned.
Sure, those are just a few of the people, right?
Yeah.
And yet Kathy Burden faces 8 felonies in this case, and the people I just mentioned haven't been charged with a thing, right?
Yes.
Never interviewed Sean Flynn?
No.
Never interviewed Stu Sandler?
No.
Never interviewed Mike Roman?
No.
Isn't it true that you, in your affidavit, either ignored or left out some exculpatory evidence related to Kathy Burden?
No.
How about Defense Exhibit B? Do you know, remember that document that she signed on December 14, 2020?
Oh, yes. I'm familiar with that.
Give it to you. Sir, is Defense Exhibit B contained anywhere in the affidavit you presented to the magistrate judge seeking charges in this case?
No.
Why not?
This is a separate document. This document never made it to the National Archives. I found no evidence of that. It never made it to the US Senate. I found no evidence of that. And the document that I received in the course of my investigation was blank. It didn't even have Kathy Burden's signature.
So I was wondering, because I didn't see the signed version in the discovery, so you didn't even have that?
But I had the document.
The blank
The
document.
blank document. The blank document was provided to me by Troy Hudson's counsel, Eric Gloucester.
Right? The blank document,
Yes.
not the signed document.
No.
And you know that exists now, okay?
You're looking at it right now, sir.
All right, well, we introduced it already in this case, there are other witnesses, right?
Yes, to answer your question.
Okay. All right, and so you see that document in front of you, right?
Yes.
And you see that Ms. Burden signed it, correct?
Yes.
And we know she signed it on December 14, 2020, correct?
Yes.
And we know that because it was notarized, correct?
Yes.
And it was notarized by Henrietta Toe, correct?
Yes.
And Henrietta Toe is an MRP employee, right?
Yes.
And she was present on December 14, 2020?
Yes.
you agree with me that this notarized document, Defense Exhibit B, is very clearly, it has conditional language in it?
Yes.
You see where it says the Republican alternate electors, quote, would cast their votes for Donald J. Trump.
Yes.
Would you agree with me that notarized documents take on greater legal significance than those that are not?
I would say the notary adds proof that the signature was witnessed by somebody else.
So it adds hallmarks of authenticity.
Yes.
Now, in fairness to Ms. Burton, don't you think when we're evaluating a specific intent, we ought to look at this document, Defense Exhibit B, at the same time as we're looking at other documents that you presented in your affidavit?
Yes.
But you didn't give the magistrate judge that same opportunity, did you?
No. I didn't have it, the document with her signature.
That's fair. So do you remember when you first saw the signed document?
Well, I allowed to, we had met in some sort of attorney process.
Me and you?
Yes.
Okay.
So.
I gave it to you?
Am I allowed to talk about that?
No, okay. That's fine.
Is that?
Sure.
Okay. Yeah, so that was the first time that I saw it.
Well, I'm glad you got it as part of your investigation. So you got that after July of 23 when you filled out your affidavit, correct?
Yes.
After charges were filed, correct?
Yeah.
Does that document in any way change your opinion of Ms. Burton and her specific intent in this case?
No.
Doesn't.
No, there's two documents that were signed by Mrs. Burton.
Huh?
One document is intended just as what it says in here, and it says, they were available to me to perform their duties as residential electors. The other document did not say that, but both were signed. Again, this document didn't go to the Senate in the National Archives. This document, I had no evidence to suggest that this document was attempted to be delivered to the Capitol, state of Michigan Capitol at the time.
So the Defense Exhibit B is not a certificate of votes. A certificate of votes get mailed to Washington, D.C. pursuant to federal law, right?
Right, I understand.
That's not what Defense Exhibit B is. So when you keep talking about the fact that it's not mailed, that's kind of besides the point. Okay, we're trying to establish Kathy Burton's intent on December 14, 2020, between about noon and 1:15. Fair?
Yes.
And Ms. Burton signed Defense Exhibit B between noon and 1:15 on December 14, 2020, correct?
Yes.
And so she signed a clearly contingent document at that time, right?
Yes.
And then another document was placed in front of her, and her signature appears on the signature page, right, of People's Exhibit 14, right?
It appears on the signature page and the alternate elector pages as well. There's 3 pages that appear.
You say alternate elector pages, do you mean the replacement elector?
I'm sorry, the replacement. Yeah.
Okay, so we'll get to that if you want to. That's where Mr. Renner was one of the replacements,
Yeah.
right? And I forget who the other one was. Off the top of my head.
Um,
Doesn't matter.
Yeah.
Okay, so that's over here. Thompson. All right, but let's do this. Where's? Okay, we've heard a bunch of testimony, obviously, about this document. That we don't really have conclusive information that page 2 and 3 of that document were presented at the same time to all 16 electors that were in the room at the MRP headquarters, do we?
Yes.
Didn't we hear testimony that that signature page was kind of sitting there standalone?
During the course of my investigation, I had mixed reports that the signature page was standalone, but also others reported that there were some other documents on the table along with.
Right. So we really don't know if Kathy Burden signed a standalone signature page, which is also Defense Exhibit C, and whether she actually saw the page that comes before it in People's Exhibit 14, right? Yeah. And so, again, my question to you is, in fairness, in July of 2023, you had no knowledge of Defense Exhibit B, right?
Yes, well, no, I had knowledge of I have the knowledge of the document. I had no knowledge that it was ever signed or anything like that.
It's fair distinguish, or a fair point. So let me restate the question. In July 2023, when you submitted your affidavit in support of charges in this case,
Yes.
you were not aware that Kathy Burden signed in front of a notary Defense Exhibit.
Yes.
And we've established that what's important for these charges is Ms. Burden's specific intent to defraud between noon and 1:15 on December 14, 2020, right?
Yeah.
You now know that in that time period, she signed Defense Exhibit B, correct?
Yes.
And that document is clearly contingent in nature, right?
Yes.
My question to you is, does that change your opinion of Ms. Burden's specific intent?
Has been asked and answered. He's answered that.
And may I have it again?
He said, no, he gave the reasons why.
Still no?
Yes. Still no. I
This is staged. We can move on.
All right, you kind of focused on mailing of the documents to Washington, DC, right?
talked about that.
Okay. Now, while Ms. Burden's name is on the envelope, you know from your investigation that she did not mail those documents to Washington, DC, right?
It doesn't.
You know Sean Flynn.
Again, we talked about that. I had information that Sean Flynn had talked to Kathy Burden in an email. He sent an email to Mike Roman, John Black or something, stating that he had talked to Kathy, that asking if it was okay to use her address. I have Tony Zammit had indicated in his conversation with Sean Flynn that the next step was to mail the documents off. But I didn't have, I don't have, physical evidence to show who exactly was at that post office at that, when we talked to the postal inspector.
Right, no, I know. I saw that in your affidavit at paragraph 25, where you talked about going to the post office and all that. So we know it was mailed from the East Lansing, Michigan post office on December 15, 2020, right?
Yeah.
And you know that that happened around the early afternoon, around 2 or 3 p.m.?
I would have to look at that.
All right. Now, I know the emails you're talking about where Sean Flynn tells Mike Roman and others that he talked to Kathy Burden, but you know he didn't talk to Kathy Burden, don't you? We went through that. Sean Flynn texted and connected with Stu Foster. He asked Stu Foster to reach out to Kathy Burden about her address and making sure that was correct. And then Stu Foster then communicated back to Sean Flynn. You know, right?
Now that you're recalling it, I don't recall.
All right, let's
But
see.
as you're recalling it,
Do you recall it now?
I don't, if I can refer to my notes.
Well, I don't know what notes you refer to, but if you have notes that confirm that, sure, you can look at that.
Or have, part of the report.
I'm handing you a text string between Sean Flynn and Stu Foster.
So you had this at the attorney process. I did not,
But
you provided this to us at the attorney process. I don't recall this being a part of my investigation. This document and your signed document by Kathy Burden here, you presented to us at the attorney proper. That was the first time that I saw it.
okay,
So as you're refreshing my memory, yes, I remember you doing it.
He's now part of your investigative file.
They're an exhibit, yes.
Do you dispute their authenticity?
No.
Is this in fact communications between Stu Foster and Sean Flynn on December 14, 2020 and December 15, 2020?
Well, I don't, I have a, what I'm looking at here is, and I haven't read all of it, but what I'm looking at here is a screenshot of a text message. I don't have anything to suggest, maybe I'm missing it, that says that it's from Stu Foster. So I can typically, when we do an investigation, this would be a lead, and we try to verify that through search warrants, obtaining additional data or evidence to show that, yes, they communicated. So I don't see Stu Foster's name on here, but
Okay,
so
did you collect Stu Foster's phone?
no, I do not.
No? Didn't think that was important?
We reviewed the phone. He allowed us to take screenshots of specific messages, and that was it.
Okay, and this is not one of the things he gave you, because I'm pretty sure this document we received through the AG's discovery. You're not thinking?
I don't recall seeing it. I remember the first time that I saw this was when we were in the attorney proper and you presented.
All right. And so if this, and I think there's other, but if this evidence suggests that Sean Flynn sent a text message to Stu Foster on December 15, 2020 at 2:55 p.m. while he's at the East Lansing Post Office, wouldn't that be important information as to who mailed these documents to Washington, D.C.?
Yeah.
That's assuming a lot of facts that
Well-
are not in evidence.
Well, but.
Address the objection.
That there is evidence that very strongly suggests that what I state, all the facts that I just stated are accurate. This text has a priority mail, picture of a priority mail, US Postal Service sticker that very much matches the information that was on the actual envelope that gets sent from the East Lansing Post Office on December 15, 2020. So when Sean Flynn is communicating with Stu Foster and he sends a picture of the thing that shows up on the envelope, it is highly probable that that's where he was. And there's more information in the discovery. I don't have it right here, but we'll, if this case continues, we'll get it. Sean Flynn is the guy that mailed these documents, and your investigation, certainly after I showed you this, should have shown.
What facts are you objecting to?
I'm objecting to that the text message was sent from the East Lansing Post Office. We have yet to verify that this is a conversation between Stu Foster and Sean Flynn, and also hearsay.
How do you know that the text message was sent from the East Lansing Post Office?
Well, from other documents, but even within this, and I can ask the question, maybe.
Other documents that were.
Just produced in discovery, not part of, not in the record yet. But I will ask a question. Does I think somebody testified to, does the fact of the blue border behind the priority mail give you any indication that this is where that picture was taken? You see the blue behind the sticker?
Yeah.
Are you aware that the East Lansing Post Office has a blue counter?
No,
You're not aware of that?
no.
All right. But in context,
Well, we still have to address the objection.
to address if this is between Stu Foster and Sean Flynn, I mean, in context, you read it, right? It says, it starts with, you gotta call Troy, that would be Troy Hudson.
You're not addressing the objection.
Oh, sorry, what's the objection? I'm sorry.
She said it is assumed fact that's not an evidence. One was whether or not, how do we know this was sent from the East Lansing Post Office? I don't think that we've been able to establish that. What's the other one, Slogan?
that this is a conversation between Stu Foster and Sean Flynn. The witness has said that he cannot identify that this is a conversation between those two.
He has stated that, and he said that if he had something else that could identify, or maybe it's in his notes, but that's not been identified. So the objection sustained.
Thank you.
After you received this document handed you didn't, did you follow up on it?
You never gave it to us. You gave it to us at the proper and then took it back. So I never had the ability to take a picture of it or anything like that. And it was my understanding that that conversation and this information was just to be kept between the attorneys. So you didn't leave me with any investigative leads to follow up on.
Certainly. Okay. Well, certainly you were presented with information that suggested that Sean Flynn was the person who mailed these documents on December 15, 2020, correct?
I have information that suggests that he was involved in the mail, yes.
But you haven't confirmed that yet.
No, and I did take that information, just looking at the snapshot. And again, focusing in on Mr. Chesbrough's evidence and paired him up, which, okay, Mr. Chesbrough presented an email that was similar in nature. So to your photo that you presented to us.
You didn't go back to Stu Foster.
No, Stu Foster didn't want to talk to me. The second time I reached out to him, he made it clear he didn't want to participate.
All right, but I mean, you've executed a ton of search warrants in this case, and if you felt that he had information that was relevant to your investigation in his phone, you could have very easily gotten it, right?
I wouldn't say very easily, no. I mean, there's a process in order to secure.
Strike very easily. You could have gotten an image of his phone if you had wanted to.
Yes.
All right, let's talk about Mr. Chesbrough. Okay, you are aware that he is an attorney, right?
Yes.
And he worked on this alternate elector plan as it occurred in Michigan and also the other 6 states, correct?
Yes.
And let's just be clear, the other 6 states are Arizona, Wisconsin, Pennsylvania, Nevada, New Mexico, and Georgia. Are you aware of that? I said Pennsylvania. Yes. All right. You've interviewed him, Mr. Chesbrough, on December 6th. Is that right?
Yes.
Who else was present for the Chesbrough interview?
His attorneys, AAG Van Langeveld and AAG Fremont. He was just
Ms. Logan present? No.
I don't believe so.
Okay. And does he have any kind of deal or immunity? I think you said to Ms. Chartier that he was there pursuant to a proffer agreement, but I just want to make sure I understand.
A proper agreement. It was at that time. Where we're at with that, I guess.
Let me ask you bluntly, was he told he wouldn't be charged?
No. I don't recall ever us ever telling him.
Okay, so
meaning those seated at the table.
Okay, so to your knowledge, he doesn't have immunity
That's mine.
in Michigan for these
No.
events. He told you he worked for Al Gore in challenging the election results in Florida back during the 2000 presidential election.
Your Honor. Need to object. This is hearsay.
Well, I'm building up in terms of what is Mr. Chesbrough's education, his history, how come Mr. Chesbrough is involved in this, that kind of giving some background about what it is that this alternate elector concept came from, and it adds to the 1960 Hawaii and the 2000 election, I believe is something that the investigator would have considered, and so I'm trying to just get into the conversation that he had with this witness.
You can ask this witness about Jeffrey's background history.
Not much.
Oh, I thought that's what you were saying. What is it, being off the truth of the matter asserted?
Well, no,
What is the objection?
yeah, no,
What
it's
is the
not.
purpose of this being off?
It's really that he considered it. I mean, did he consider it? As part of his investigation. All right, let me ask this. Maybe we can
Are
start.
you withdrawing?
No, I'm not withdrawing, but maybe I'm gonna ask a quick question that maybe gets around it entirely.
Well, we can't skip over an objection and ask another
Fair.
question.
No, I don't. So I would say it's effect on him, but I think there's another potential either hearsay exception or non-hearsay point that I'd like to raise with the board. I need another question to do that.
What would be your follow-up question for that?
Is Mr. Chesbro an unindicted co-conspirator?
Well, you don't have to answer that because we're addressing the objection. So understanding what his next question is.
Well, I don't think Mr. Chesbro's work on the Gore Bush campaign in 2000 has, well, first of all, there's been no foundation laying how this witness would know that other than if he got it from Mr. Chesbro himself, which would make it hearsay. And plus, even with the follow-up question, that still doesn't make the answer any less hearsay. The only point of the follow-up question, if Mr. Chesbro was an unindicted conspirator, would make openings for statements made in furtherance of the conspiracy. So anything happening in 2000 would not be in furtherance of the conspiracy that occurred in 2020.
First, the purpose that you were offering this was so that you can lay some foundation about the background. And I don't know if you've been established if he knows any of this information directly from Mr. Chesbro. So maybe we should go that route first. I am going to sustain the objection the way the question was asked.
Okay. I really only have one question about the 2000 presidential election, which is, did he tell you he worked on Al Gore?
Judge, you're
Did he hear
Chesbro,
from
sorry.
Chesbro directly?
yeah, did he tell you?
Do you want to respond to the objection?
I think it's a proper question. Again, I don't think
What's
that's
its
that important.
evidentiary of value though?
Yeah, well, I just think that it goes to, I mean, I don't think this is worth going into so much, but there was a lesson learned from the Gore v. Bush presidential election. That was a very tight election and things got missed in that election, and Gore gave up a lot of things that had he not, he might have very well won that election. So there were lessons learned from that that informed Mr. Chesbro's decisions on this alternate elector certificate of votes.
Okay, so you're trying to ask questions about that to establish whether or not this witness knew why he did what he did in 2020?
In 2000, yeah, and in 2020, sure, because my assumption is that the lead investigator on the case, who's continuing his investigation even after charges have been filed, is trying to learn things by doing the interviews that he's doing. And so if the witness, Mr. Chesbro, is informing him as to why he drafted an alternate elector certificate of votes, I would think this witness cares about that. And he would evaluate that information and use it to determine what should be done as this case progresses.
So I think the witness can testify if you would ask that way, why Mr. Chesbro drafted the document, if he determined that from his conversation with him, why he drafted the document the way he did. But as to her objection, then he'll say you haven't provided me a valid reason to get beyond that hearsay, so the objection is the same. Thank you.
Thank you. Okay. Are you aware that Mr. Chesbro drafted various memos explaining how to implement the alternate elector plan?
Yes,
Have you reviewed those memos?
yes,
Did you review those memos before signing your affidavit in July of 2023?
no,
So you reviewed them afterwards?
Yeah.
All right. I want to walk through those memos. Before I do, anything in those memos that changed your opinions about this case?
I would say that they had an impact on me, like we talked about earlier, when new information or evidence is brought in. It has an impact to go. You know, I was able to deter from that.
All right. I am approaching the witness and handing him what I've marked as proposed defense exhibits F, G, and H. I ask you to take a look at those and see if those are documents that you followed with me.
Yes, sir.
Okay. I'm going to take a shot, Your Honor. I move for the admission of defense exhibits F, G, and H at this time.
I object.
Okay, then I'll do it. That's fine. I didn't lay any foundation, so I won't do it. I was just trying to cut this short.
Let me stop you real quick. Something's going on. So, I can't. Timed out. Because it only gives you, I think, 8 hours. Oh. I don't know.
It shows on camera this morning.
Yeah, just pull this out. Ms. Lundgren, can you hear us?
Oh, damn.
Just, thank you. She can hear us. Okay. Was there an objection?
Yes, well, one, they haven't been admitted yet, so I'm going to object to counsel reading from these documents, and they're also hearsay.
So, I
Well,
thought
here,
we were gonna lay some foundation.
Yeah, and here I'm clearly going on the effect on him because he said after he read them, they did impact him. And so I want to explore how.
He did say they didn't affect him.
But I believe we can just, that question can be asked and answered without eliciting hearsay statements within this document.
Well, look, Your Honor, I think these statements are fair. They were things that this witness either did and certainly should have evaluated as part of his investigation, ongoing investigation. This is about the person who drafted the document that is the basis for the state's charges here. And so to understand what the drafter of the document was contemplating at the time he created the documents is very relevant. And I would imagine it has to be very relevant to this witness and should be very relevant to the court in making its find over decision.
Doesn't make any sense.
Well, but I think it's important in the
He's
witness.
not offering for the truth of matter
Right.
asserted, he's offering for the effect of the listener, which needs to come in.
Well, the effect on the listener does, the document does not.
You said, repeat that?
So the fact that the witness read the document and the effect that the document had, that comes in as testimony. This does not come in as substantive evidence because it had an effect on the
We've
listener.
not admitted the evidence, he's questioning him about it, I think he's trying to lay a foundation to get it admitted. He's questioning about statements that was in there and how I assumed that affected Agent Shock when he was making the decision, and this is again a document that purports to provide information as to what the drafter of this alleged slate was thinking, I suppose. I think some critical information. The objections over here. Thank you.
Okay. All right, sir. So here, what I'm doing is, so I want to know, not only did each of these memos, whether they impacted you, but I want to know specific portions of the memos impacted you in the course of your investigation, all right? So what I'd like you to do is I'm going to direct your attention to the second paragraph under summary, first paragraph under summary. It states, and again, I want to know if this had an impact on you, that quote, if a court decision, or perhaps a state legislative determination goes in Trump's favor after December 14, 2020, but before January 6, 2021, the only real deadline is the December 14th deadline to cast electoral votes. Did you see that?
A court's decision,
That's right.
that's in the summary.
I'm sorry. It is the second paragraph. I'm sorry. So
I just want to stop you.
I'm
You
sorry.
asking him if this particular paragraph is what, or had an effect on him, or? Oh,
I'm sorry. Yeah, it's my fault. I didn't orient you correctly. So under summary, it is the second paragraph under summary. See where it says January 6th? In the third line?
Yes.
That's where I was reading. from.
Okay.
A court decision or perhaps a state legislative determination rendered after December 14th in favor of the Trump-Pence slate should be considered time. Do you see that?
Yes.
Do you see that this language focuses on something that would happen after the electors voted?
Your Honor, I would ask that
Can
Let's
you
do
read
it.
that, can you?
Oh.
Sentence
yes,
for context?
yes.
I'll read the sentence, but my point remains. If we're gonna start
How
saying
do-
rule of completeness, this
How
document.
do
is
we
complete.
just read one sentence out of a paragraph and that gives us context?
Exactly.
How do we read a portion of a sentence?
How do we read?
I
exactly, let's
agree,
get
no, I
there.
agree, we can't read a portion of the sentence, but if you're gonna give me some context, I might need to know what the whole paragraph is talking about. Cause I don't know.
Well, I object to the whole thing, but I know I'm understanding and respecting the court's ruling. If we're going to read portions, it has to be the whole sentence, or it takes the statement out of context.
I completely agree to that, but I also can understand certain sentences read by itself could be read out of context. And I have no clue what this I have no clue what is being read right now.
Right.
And so for the purposes of my education, I want the entire paragraph.
And I will 100% do that, but Your Honor, may I say something?
Yes.
I'm here as a defense lawyer trying to provide additional information to the court for purposes of its decision, which is a very critical decision. It's odd to me that the state doesn't want the court to see critical information in this case. I understand there's an evidentiary basis perhaps. However, if we're talking about context and completeness, and again, I don't want to be somebody who's reading sentences out of a memo out of context. I read a memo in a certain way. I pull out certain pieces of it because they resonate with me. Other portions might resonate with you differently. So I am all for this court seeing these 3 memos in their entirety. I think the memos are critical. I think they're crucial to the court's determination. They go into the contingent nature of this document, which has been part of a defense theme. And I'm not sure why we're keeping away from the court.
You may. Your Honor, the court has heard a lot of testimony. There are a lot of decisions in this case, but the rules of evidence are there for a reason. And they have to apply no matter how important the context of a memo might be. And the rule of completeness is one that is very important because just reading the middle of a sentence to the end changes the scope and the landscape of it.
I agree, which is why I requested him to read the entire fact.
Okay, I will do that. Okay, so on page 1, it's the 3rd paragraph in the memo. And the second one under summary, it says, assuming the electors pledged to Trump and Pence end up meeting at this, now this is, it's not. I'm gonna go back, excuse me. Let me read it from start to finish. Assuming the electors pledged to Trump and Pence end up meeting at the Wisconsin Capitol on December 14th to cast their votes, and then send their votes to the President of the Senate in time to be opened on January 6th, a court decision, or perhaps a state legislative determination rendered after, and after is under, December 14th, in favor of the Trump-Pence slate of electors should be considered timely. On this view, the only real deadline during the next month is the December 14th deadline to cast electoral votes, so that any state judicial proceedings which extend past that date, working toward resolution of who has won Wisconsin's electoral votes, are entirely compatible with federal law, provided that they are completed by January 6th. Did I read that correctly, sir?
Yes.
Okay. So I did read a portion of it, but does that tell you that at least that portion, tell you that what Mr. Chesbro was focused on was some event happening potentially after December 14, 2020, that might have changed the state's, here in Wisconsin, election results?
Yes, in Wisconsin.
Okay. Well, I was going to read a portion, but I'd like to, I guess, read for completeness. The top of page 2, I was only going to read a little bit, but I'll read the entire paragraph, first paragraph.
You still on your.
I'm sorry, yes,
you
I'm
on
still
your
reading from
proposed exhibit F?
proposed exhibit. The other date of particular significance is the date that the 10 Wisconsin electors pledged respectively, to Trump, Pence, and Biden-Harris must meet in Madison to actually cast their electoral votes, if those votes are later to be eligible to be counted in Congress on January 6th. Okay, I'm going to stop there then. So do you see where it says, if those votes are later to be eligible to be counted?
Yes.
Does that sound contingent to you?
No.
It doesn't. If is
I'm
not
sorry,
a.
yeah, I'm sorry, I got confused. Yes, if those votes are later to be, yes, it does sound. In Wisconsin.
Well, this letter, this memo is written to Judge Trupis, who's in Wisconsin. You testified already, right?
Yes.
I want to read the third paragraph of page 2 of Defense Exhibit F. Prudence dictates that the 10 electors pledged to Trump and Pence meet and cast their votes on December 14th, unless by then the race has been conceded, it is highly uncertain, given the language in Article 2, requiring that all electors throughout the United States vote on the same day, whether Congress could validly count electoral votes cast on a later date. You see that? So doesn't that tell you that the Constitution of the United States requires a vote of electors on December 14th of 2020?
Yes.
If there's any chance for those to be collected or counted by Congress on January 6th, 2021?
Yes.
And Mr. Chesbro is not just making that up. Again, that's in the Constitution of the United States, right?
Your Honor, I'm gonna object, that's speculation, unless we get foundation, how he knows how Mr. Judge will use this information.
Well, I think he followed it up with, that's in the Constitution, so. If it's in the Constitution, I think it's a question.
Yeah, if you don't know, that's fine.
I would,
But as to the first part, you can't speculate as to if Mr. General made something up. But he followed up with the question, is that from the Constitution, so that's why I'm allowing it.
Yeah, I was just objecting to the first portion.
We can, yes.
The date that the electors have to vote is a constitutional requirement. Are you aware of that?
yeah.
And are you aware that this actually occurred in our nation's history? Back in 1857, and I think I want to know if you know this, the Wisconsin electors in that year, long time ago, but they voted a day late because of a blizzard. Yeah, you aware of that?
Yes.
And Congress debated for 2 days whether they could count the electoral votes from the state of Wisconsin back in 1857 because it was issued, because they signed and the certificate of votes a day late. You aware of that?
Yes.
And they never resolved the question because it didn't really matter for that election. But that date, that shows that this date is a real constitutional and federal law significance, right?
Yes.
All right, the next paragraph. Oh, and I'm on page 2, paragraph 4 of the Defense Exhibit F, proposed Exhibit F. It may seem odd that the electors pledged to Trump and Pence might meet and cast their votes on December 14th, even if at that juncture, the Trump-Pence ticket is behind in the vote count, and no certificate of election has been issued in favor of Trump and Pence. However, a fair reading of the federal statutes suggests that this is a reasonable course of action. Did I read that correct?
Yes.
That statement impact you?
Yes.
Do you think that what Mr. Chesbro did here in creating an alternate slate for 2020 was a fair reading of the federal statute?
You're asking for my opinion?
Yeah.
On what he did is fair?
Yeah.
I don't see it. That's my opinion.
Sure. And you've testified before that this is not easy stuff, right?
Yeah.
And people have differing opinions, right?
Yes.
And there are legal scholars on one side of this debate, right?
Yeah.
And legal scholars on the other side. Fair.
Yeah.
All right, let's look at. I'll try. Let's look at proposed defense exhibit G. Proposed defense exhibit G is another later memo from Ken Chesbro to, again, James Trupas, dated December 6, 2020, correct?
Yes.
And you reviewed this document?
Yes.
Again, you reviewed it after July of 2023.
Yes.
do you see in section 1A, and I'll just read the whole thing. All the Trump-Pence electors meet and vote in all 6 contested states and send in the certificates containing their votes in compliance with federal and state statutes on December 14th. Did I read that correct?
Yes,
Did that impact you?
yes.
At the bottom of page 2 of the memo, where it's section 2, see that messaging about?
Section 2.
Section
C.
Sorry. No, page 2. Sorry,
Okay.
bottom of page 2.
Okay.
Yeah, oh man. Okay, I'll read the whole thing. If the Trump campaign ends up deciding to have all of its electors vote on December 14th, even in states in which Trump has not been declared the winner, presumably word of this will leak out prior to December 14th. So perhaps before then, there should be messaging that presents this as a routine measure that is necessary to ensure that in the event the courts or state legislatures were to later conclude that Trump actually won the state, the correct electoral slate can be counted in Congress in January, just as the Democrats did in Hawaii in 1960, which ended up with Hawaii's electoral votes being awarded to Kennedy, even though the litigation was not resolved until after the electors voted. Did I read that correctly?
Yes.
So we see here that Mr. Chesbro is relying on 1960 Hawaii, right?
Yeah.
And do you see the words in the event the courts or the state legislature were later to conclude that Trump actually won the state?
Yes, but our document didn't have continued language.
Right, we're gonna get to that.
Okay.
But I read that correctly, correct?
Yeah.
All right, last one on this one. Bottom of page 4. Kind of goes into the reason for casting an alternate Republican slate. Let me just orient myself here. All right. Well, actually, I'm gonna do a little bit more. Were you aware, did you read this CNN article by Van Jones and Larry Lessig? It's in the memo.
Oh.
It's in the middle of there. I was gonna go to the bottom of it.
Yes, I see it. What you're saying now.
So you read this.
Let's see, November 4th. Yes. Yes, I did review that.
And I'm asking because, again, if I have to read the whole paragraph, I need the rest of it for context because it starts with given such prior statements. So the prior statements are above, and it talks about the CNN article. That's why I'm trying to ask.
Okay.
So, did you read the article?
Yeah.
Okay. Are you aware that that article came out the day after the election? November 4th, 2020?
It says right in here that it came out on November 4th.
Okay, fair. There. Okay.
Yeah.
Got the date right.
I don't recall the specifics of the article. I remember reviewing the article.
Do you remember that this is, again, it's CNN, it's Van Jones. This is at a time where Pennsylvania was looking like it was going to go in Trump's favor. Are you aware of that?
I don't recall.
And the article talks about the use of alternate electors by the Democrats. Are you aware of that?
I don't recall.
You don't remember that in the article?
No, that's what I said earlier. I don't recall. I remember reviewing the article. I don't recall the specifics of the article.
Do you remember anything about your investigation, whether it's in this article or otherwise, where there was some brainstorming on the Democratic side about the use of alternate electors?
I don't recall.
Would that influence or in any way cause you to think differently about this case if you knew that the Democratic side was considering the use of alternate electors?
I mean, I could play what-ifs and should-ifs all day long. I'm focusing on Michigan here and the information that I had in front of me. So I don't recall that information. But as any amount of information that comes into my review, I mean, things like this document that we're reading, yes, it does.
Okay. All right, let me read the last paragraph. And again, I needed to do that because it at least puts this into some context. It says, given such prior statements by these and other prominent liberal figures, it would be the height of hypocrisy for Democrats to resist January 6th as the real deadline, or to suggest that Trump and Pence would be doing anything particularly controversial in asking the electors pledged to them to please assemble in their respective states and cast their votes and transmit them to Washington on December 14th so that they might be counted in Congress if their slates are later declared the valid ones by a court and/or state legislature. Did I read that correctly?
Yes.
Aren't the words that are used by Mr. Cheesebro in this paragraph that I just read? If, so they might later declare to be the valid ones by court, aren't those very contingent on the future event happening between December 14, 2020 and January 6, 2020?
Yes.
All right, last memo. Defense proposed exhibit H. I'm just going to read the first sentence. I'm sorry, strip that. This is a memo from Ken Chesbro to James R. Trupis dated December 9th, 2020, correct?
Yes.
And the first sentence reads, here's a summary of the requirements under federal law and under the law of the 6 states in controversy concerning what is required for presidential electors to validly cast and transmit their votes. You see that? You see the word validly?
Yes.
Did that impact your investigation?
Yes.
All right, this is a little repetitive, but I think consistency is important in what Mr. Chesbro was writing about this document that he drafted, the certificate of votes, which is.
Yeah. I'm sorry, I'm gonna object, because are we talking about consistency of what Chesbro saying or the effect of listening?
The left.
We talked about the effect of listening, not bolstering Chesbro with his own memos.
Did you want to respond to the objection? I don't know if that was actually an objection.
It is an objection, Your Honor.
The objection is that he's bolstering.
He's bolstering Chesbro's opinion with his own opinions, and I don't think that is permissible under the rules of evidence. And he's using this witness to basically bolster his memo.
Well, he's asking them whether or not the language in the memos had any effect on him. He's not gotten into how that affected him, but maybe he's going to do that once he gets through F, G, and H.
We're done with G, Your Honor. I'm not
Yeah,
H.
so he's still on H, and maybe he was gonna wrap it all up, he takes the scenic route, so. Maybe that's what's going on, I'm hopeful that that's a question, if it wasn't, I was gonna. So I'll allow to read this question.
Second paragraph, at least the first, it's a long sentence, but I think it's one sentence. It appears that even though none of the Trump-Pence electors are currently certified as having been elected by the voters of their state, most of the electors, possible exception of the Nevada electors, will be able to take the essential steps needed to validly cast and transmit their votes, so that the votes might be eligible to be counted if later recognized by a court, the state legislature, or Congress, as the valid ones that actually count in the presidential election. Did I read that correct?
Yes, sir.
All right, and that also impacted you in some way?
Yes.
We're going to get to the how. All right, take a look at page 2, and I can read it if you want. The 4th bullet point. And again, I'll read it, but does the 4th bullet point essentially acknowledge that what Chesbro is saying, that there's not going to be a certificate of ascertainment with the certificate of votes as of December 14, 2020, just like it was in Hawaii? Or would you like me to read it?
No, that's what it says.
So Mr. Chesbro is acknowledging in this memo that there's going to be no certificate of ascertainment that accompanies a certificate of votes, right?
Yes.
And we went through that for the 1960 case, is the Democratic alternate certificate of votes didn't become valid or of legal significance until the certificate of ascertainment came on January 4th, 1961, correct?
Yes, and that's a sense, so in order for it to be that. So the certificate of ascertainment was sent.
Okay, so what we went through there, and it was the scenic route, what we went through there is a lot of information that you had after July of 2023, which showed you that the person who put this plan together, this alternate elector plan that was used across 7 states in the United States, including Michigan, was drafting memos for others to review that talked about the contingent nature of the document. True?
Yes.
How did that information impact you? That, okay, let me take a step back. The charges here seem very focused on the 4 corners of People's Exhibit 14. Do you agree with that?
Yes.
What Chesbro is essentially saying in the interview you had with him, in these memos, is that you have to read that document in context with what's going on in the world around you. Fair?
What he's saying?
Yeah.
Does this still affect on the listener?
Yeah.
He's asking him how it affected his.
Well, he asked what was Chesbro saying, basically asking him to explain what Chesbro was saying. Which is
Are you asking
different
what
than-
he, and are you trying to get what he's interpreting Chesbro's
I'm trying to get.
intent to be, or what he physically said?
So where I look, I mean, I think I can get there the way I'm going, but I'll just state it bluntly. Agent Schock filed an affidavit in this case in July of 2023. He did not have the benefit of an interview with Mr. Chesbro. He did not have the benefit of the 3 memos that Mr. Chesbro drafted about this document that is very offensive to the state of Michigan. And what I want to know is, after he reviewed this stuff, did it matter?
That's
Well, I'm
the
asking it now.
question. So we'll withdraw his previous question and we'll take that.
Let's do that. Did you hear it? I don't know if I can do it
The
as good as
second,
that.
the second question, yes.
All right, what's your answer?
I said yes.
It mattered.
Yes.
How did it matter?
It's more investigative leads.
And would you say that the guy who drafted this document believed that document to be contingent on a future event is very significant to your investigation?
Yes.
Okay. just a quick about the certificate of votes being married up with the certificate of ascertainment issue. Do you remember when the National Archives witness, I think her name was Miriam Vincent, basically testified to that? She said the certificate of votes has no legal significance until it's married up with the certificate of ascertainment. Do you remember that?
I vaguely remember that, yes.
Okay. And do you believe that to be true?
Yes, I mean, she would know, she's the authority on it.
All right, I'm gonna take a stab at it, Your Honor. I think the court has listened to me read from certain paragraphs of this. I think I've made the points I want, but if the court wants proposed defense exhibits F, G, and H, I think the proper foundation has been laid. I think they are important to the court's determination, and so I'd offer them as evidence in this case.
You continue with your instructions.
I am, Your Honor. Effect on the listener does not permit the documents themselves to be admitted substitute. The documents themselves are still hearsay.
We have the statements, you read them on the record, so I don't know that we need the entire document submitted as an exhibit, so if the objection is sustained.
All right, thank you, Your Honor. Okay, so Mr. Chesbro told you that he drafted the language in a way of the certificate of votes, the People's Exhibit 14 and the other companions across the other states, in a way to be compliant with the law. Is that what he told you?
I don't remember specifically what he told me, but I do remember that he tried to create similar documents that were already on file with various states.
Okay. And do you remember him telling you that he forwarded drafts of those documents to Mike Roman, who's worked somehow for the Trump campaign?
Yes.
And he sent those to Mike Roman prior to December 14, 2020, right?
Yes.
Okay. All right, we'll get back to Mr. Roman. Now, you talked about this, so I want to go through it. You said that Mr. Chesbro had a list of the Michigan Republican electors, and didn't he tell you that he guessed as to which ones to contact based upon their status?
Yes.
And he picked Ms. Burden because she was the national committee woman. We talked about that, right?
Yes.
And he also sent that same email to Ms. Sheridan for similar reasons, correct?
Yes.
And you're aware that Kathy Burden never responded to Mr. Chesbro's email, right?
Yes.
Ms. Sheridan did, right?
Yes.
And in fact, it's not only responding to that email, but Mr. Chesbro told you he never talked to Ms. Burden, correct?
Yes.
Or communicated with her in any way.
Yes. Well, other than the initial email.
Perfect.
Right.
And so let's just put context on it. That was a December 10th, 2020 email, correct? You want to see it?
That sounds about right, yes. It was somewhere around that time.
And the email, and maybe I can show it to you, but Ms. Sheridan says she could be more effective than Ms. Burden, correct?
Yeah.
Okay. Did Mr. Chesbro explain to you why he didn't think there had to be conditional language directly in the certificate of votes? Do you remember him explaining that to you during your interview?
I remember it was a point of discussion. Yes. I don't remember the specifics of it, and it had to do with, I think it was Pennsylvania. But I remember that being a point of discussion.
Okay. Basically, he told you that conditional language is not necessary under federal law, and he used this Hawaii 1960 certificate of votes as an example, right? One we just went through, defense exhibit E.
I don't remember him specifically saying that it wasn't required as a condition of law. I don't remember that.
All right. You've mentioned Pennsylvania, right?
Yes, I remember talking about conditional language. Again, I can refer to my report, but
Let's see, I might show it to you real quick. So you're aware that the Pennsylvania alternate Republican electors raised an issue about conditional language, right?
yeah,
And they raised that issue to Mr. Chesbrough?
they raised the issue. I don't know specifically if Chesbrough was looped in on that communication.
You don't remember emails about that, or he's very much involved?
Yes, no, he was involved in drafting back and forth, communications. Whether or not it was with Pennsylvania, somebody specifically in Pennsylvania, that I don't recall. It was, I believe it was somebody else within the group of people that he was communicating with at the time.
Do you remember whether it's from Mr. Chesbrough or just your investigation generally that these Pennsylvania alternate Republican electors raised this request for conditional language to go directly into that document because they thought their attorney general might prosecute them for political reasons?
I do remember, yes.
But you're saying you don't remember that it was Mr. Chesbrough that actually made that change to the Pennsylvania document?
No, that's not what I'm saying. I believe he made the changes, but who he was in communication with over in Pennsylvania, I don't recall that.
Oh, that's fair. Okay. But you're aware he made the change to Pennsylvania?
Yeah.
All right. Your Honor, should I, okay, the GFGH are not in, so I should go to I, even though those are in the minute, right?
Yes.
I'm handing the witness what's proposed defense exhibit I, which is the certificate of votes for the state of Pennsylvania, excuse me, the alternate Republican elector certificate of votes for the state of Pennsylvania. You see, is that what I handed you?
Yes.
Do you see the addition of conditional language in the first paragraph, we the undersigned?
Yes.
Okay. Are you aware that Mr. Chesbrough made that change?
Yes.
You've seen that in his emails, correct?
Yes.
Are you also aware that Mr. Chesbrough suggested that all the states, all 7 states, including Michigan, do the same just to err on the side of caution? Were you aware of that?
I remember somebody did. If it was Mr. Chesbrough, I remember hearing it, yes.
And the purpose and the idea was, if we're doing it for Pennsylvania, why not do it for the other 6 states, right?
Yes.
Pretty reasonable kind of follow-up, right?
Yes.
Are you aware that on his own, Mr. Chesbrough unilaterally made that change to the New Mexico Republican alternate elector certificate of votes?
I remember talking with you about the conditional language in Pennsylvania, like, viewed that down to verify what he was talking about.
And you know that he told you that while he put that language into Pennsylvania and New Mexico, he didn't believe it to be necessary, correct?
Yes.
Because in his mind, the document was conditional based on the surrounding circumstances. Yeah.
Yes.
I am handing the witness who I've marked as proposed defense exhibit J.
Are you moving to admit I?
I think I can do these both at the same time. Is defense exhibit I the certificate of votes by the alternate Republican electors for the state of New Mexico during the 2020 election?
That's J.
J.
Oh, I'm sorry. What did I say? I, I'm sorry, J.
Yes.
All right, and it too has conditional language in the first paragraph, we the undersigned?
Yes.
Now, Mr. Chesbro wanted to make that change, add the conditional language to the Michigan certificate of votes, didn't
I don't recall that.
he? He didn't tell you?
I didn't say he didn't tell me that. I just said I don't recall that.
Do you recall seeing that in the emails or text messages or anything like that? I'm sorry, go ahead.
We talked about a moment ago that he suggested that we change in all the states.
Fair.
Okay, I don't recall a specific conversation about Michigan.
Fair enough, and that's a fair, so, he told you that he wanted to change all 7 states, including Michigan, in terms of adding. a
Yeah.
condition. Do you know why the conditional language never made its way into the Michigan certificate of votes? People's Exhibit 14?
I believe somebody objected to it, but I don't recall who that would have been.
Like Roman?
It sounds familiar, that name. I know that he was having discussions with Roman on that topic.
Certainly wasn't Kathy Burton. She wasn't consulted in any way about what was going to go in that document, was she?
No.
Isn't it true that Mike Roman was the one who refused to have that conditional language added to the Michigan Republican alternate certificate of votes?
It may have.
Who's Mike Roman?
It was a Trump campaign aide. His, I want to say it was election day operations.
Do you remember Mr. Chesbro describing him as the key figure to make sure all the electors showed up on December 14th, 2020?
I don't know if it was Mr. Chesbro, but I remember him saying, or somebody saying.
And again, do you remember what Mike Roman said about just going ahead and adding this conditional language to the Republican alternate certificate of votes here in Michigan, just to make it absolutely clear that this was in fact a conditional document?
Do I remember what Roman said?
That's right.
I do.
If you read it, it's kind of hard to forget. You know what? Well, I'll read it and then I'll show it to you.
Are you gonna refresh his recollection?
Sure. I am handing the witness K that has been marked as defense exhibit, proposed defense exhibit K. And I ask you to identify what that document is.
This is a screenshot of Mike Roman's, I don't know what the face would be, a cell phone cover that just has on it all video information. It's basically the information portion of his cell phone when you're clicking on info at the time.
Okay, is that Mike Roman's picture?
Yes,
You said you'd never interviewed Mike Roman, right?
that's right.
Do you recognize proposed defense exhibit K as a text exchange between Mike Roman and Ken Chesbro?
Yes,
Is it true that in the context of what we're talking about, Mr. Chesbro says, Mike, I think the language at the start of the certificate should be changed in all the states. Let's look at the language carefully. Did I read that correctly?
yes, you did.
Is that talking about, again, the date of that text is December 12th, 2020 at 2:17 p.m. Is that correct?
Yes,
Is what I just read consistent with the time frame where Mr. Chesbro changed the language of the Pennsylvania certificate of votes and the New Mexico certificate of votes, and he's saying, let's do it for the rest of the states? Is that what this is talking about?
Chesbro is, yes.
Yes. And what does Mr. Roman say back?
I don't,
So he disagrees, correct?
yes,
And then Mr. Chesbro says, I can help with drafting in a couple hours, right?
yes,
And what does Mr. Roman say back?
it's fuck these guys.
Fuck who?
He's speculating,
Talking about Ms. Burton?
I'm speculating on who he's referring to.
Sounds like the 16 Republican alternate electors. in the state of Michigan.
So he doesn't know, we have to speculate the answer.
Do you believe, you don't, I can't, well, I'll ask the question. Do you believe that Mr. Roman is referring to the alternate electors in the state of Michigan?
Your Honor, I would object. The foundation witnesses already testified that he was suspected.
I want to know if he, what, with his speculation, does he believe in context of his investigation, in context of what's in this text string, which is very clear to me, what this witness thinks.
He's reviewed thousands of documents. He's interviewed probably well over 100 witnesses. He's been working on this case for years, 60 to 70% of the time. I think that it is extremely fair to ask for his personal opinion and based on his personal knowledge of the context of that statement, because it's extremely relevant to the investigation and what steps were taken, both before he views that document and afterward, after he reviews these documents, what steps he takes. That's why it's extremely relevant. This entire line of questioning goes to this investigation and what is being done during this investigation by Agent Shaw.
Then I don't believe that what is being asked is the context of the statement. I don't think that we need to interpret fuck these guys. What they're asking is for the witness to speculate who these guys are in the context of what Mike Roman reportedly texted. And the witness has already stated that he's not in a position to do that.
Well, that he didn't respond in that way to that specific question. When he asked who is these guys, that's when he's saying, well, I would have to speculate. He asking if it's, does he believe that these guys refers to the 16 electors is more specific and based on his investigation and him knowing the context, I guess, more fully behind that communication chain, he could respond as to whether or not he has a belief that it's these electors or whether or not he still maintains the same answer, which is, I don't know, that's special. So the objections are ruled as to the rephrasing of the question. Thank you. You can answer that.
Do you believe he's referring to?
Guys, I took that as a male term, so guys would be, I'm referring to men. Again, I'm speculating beyond. So when he says, fuck these guys, I'm thinking it's a group of men that he's referring to.
Okay. Or you think he's, do you believe that he's referring to the male alternate Republican electors in the state of Michigan when he says that?
It could be the male alternate electors, it could be the GOP males.
Okay. Bottom line, after you saw this text, you know that the reason why conditional language is not in this certificate of votes is because of Mike Roman, right?
Yes, sir.
And you didn't go and interview Mike Roman, did you?
No,
I mean, isn't he the bad guy here?
yes. I didn't say that I didn't try. I didn't interview him.
But he's the bad guy. I mean, if there's a bad guy here, it's Mike Roman, isn't it?
The investigation is ongoing.
Okay. Maybe you should charge Mike Roman and not a retired farmer. Okay.
Strike. We're gonna make a motion to admit IJ. I'm asking for this 407. And I'm gonna pause you in a minute.
I'm almost done, Your Honor.
Oh,
But I will go ahead and move those exhibits into evidence.
any objections to IJ?
Your Honor, the people have no objections to I and J. However, K is hearsay, and I do not recall hearing any line of questioning the foundation laid for effect on the listener. And so the people would object to the addition of K. It's hearsay.
Okay, I and J are admitted. Do you want to respond to the objection? That's okay.
Yes, Your Honor. Your Honor, this is, I mean, so this witness just said the investigation is ongoing. He essentially insinuated that Mr. Roman might be charged. That's how I took it. Certainly.
I don't know
and
that
I-
he's insinuating that, but
Well-
it's not, I don't think he's ruled it out because he said the investigation is ongoing. May not be Mr. Roman, it could be a number of people.
Could be. And so, you know, this document, if, if he's, I assume, well, let me ask, is Mr. Roman an unindicted co-conspirator in this case?
Yes.
So it's not hearsay as a co-conspirator statement at a minimum. I think this has to come in, certainly for context, John. This is the guy who prevented this document from having language that would have avoided these charges altogether. The document in and of itself, when read in context, is contingent, but if that language had been there, none of us would be here, right?
Okay, well, the objection was to hearsay is offered for the effect of the listener.
Yes, sir.
Okay, the objection is overruled. K comes in.
Thank you. Okay, Mr. Schock, Chesbro told you that it was unfortunate about some of the things that were done by the Trump campaign that were not in accord with what he thought they should be doing. Do you remember him telling you that?
Yes.
So per Chesbro, the Trump campaign was doing things inconsistent with what he thought the process should be, right?
Yes.
Mr. Chesbro also told you that he would not have sent what he sent to the electors had he known the Trump campaign had a broader agenda than what they told him. Remember him telling you that?
I do not.
You don't remember him saying that?
I can refer to the notes and sure read.
Well, if they were keeping things from a guy like Chesbro, imagine how little he's heard.
Strike.
And myself, is that a question?
It's fine. It's
Oh.
Do you remember Ken Chesbro telling you directly that he absolutely quote, feels misled by the Trump campaign?
Yes.
He's starting to feel the same.
Move to strike.
No further questions.
It is 4:11. We're going to begin the additional testimony today. And so we are back tomorrow, 8:30 in the morning, back in my original courtroom. You guys, that includes ladies. Make sure you get in there early. I'll try to see if they can adjust the temperature. I'm not sure what they can do in there to help it be a little bit more comfortable. I made the guys comment on me because my mom says that when I say that to her, I say guys. And so unless there's any additional matters for today, we are adjourned until 8:31. Are you free to go for today, Ms. Lundgren? We'll see you in the morning. Thank you. See you in the morning.